Hello. How are you all? Welcome. Now, first order of business. Hi, everyone. Sound okay? I have a small portable air cooler on. So if you hear a small buzzing sound in the background, that's that. Because today is warm in Sweden. Over here, sun, and it is currently 33 degrees in the sun. That would be somewhere in the 90s in Fahrenheit. So it is warm. So wearing my pure cotton shirt here, so at least my body can breathe as well. Yes, we are back at it at a young thug RICO-trial. And when we left off, we found out that there are 4 very interesting names in this trial. It is Prosecutor Love. On the stand is Assistant District Attorney Sprinkle. You also have named an Officer Fanny. And if you're British, that's funny. And then also we have one of the attorneys, who is Attorney Shart. At least that's what I heard. Now, there's been a little update in the young thug RICO trial. Yesterday was a hearing. So it wasn't long. But let's start with that, because that's the first thing that has happened in the last month. That is live, at least. So, let's see here. Yes, as you can see, it's a 46-minute clip, but the judge was late. So everything starts at 33 minutes. So let's see what this hearing is about.
United States of Georgia. Hi, good morning, council's interested parties. We're back on the record of the United States of Georgia. This is Khalif Adams et al. In 22 SC 183572. And the first order of business is to go ahead and take roll. All right, Mr. Beebe and Mr. Partridge. Good morning, Judge. Good morning, gentlemen. All right, Mr. Jackson and Mr. Boston, Mr. Shart. Good morning, gentlemen.
Mr. Shart.
Mr. Williams and Mr. Adams, good morning. Mr. Kendrick and Mr. Weinstein, good morning. Mr. Huey and Mr. Matthews, good morning. Mr. Nichols and Mr. Harvey, good morning, sir. Oh, you got everybody? Okay, Mr. Gardner and Ms. Westmoreland, good morning to all of you.
With your permission, Judge, I'm going to deal with a legal issue that helps all of us this morning. So, since everybody's here, with your permission and Mr. Nichols' permission, can I absent myself?
Yes, you may, sir. Just give me a second. I'm almost to that point, and I think I'll be able to release you sufficiently, okay? All right, thank you, sir. All right, Mr. Dorsey and Mr. Jimenez. Good morning, gentlemen. And Mr. Ryan and Mr. Williams, good morning. All right.
And that was the roll call for all the attorneys that is present.
Fine, sir. All right, I know you're handling this matter on by special designation. Good to see you again. I will take it up in just a minute. Thank you, sir. All right, Mr. Randolph, good morning. And good morning, Ms. Von Kelsch.
Good morning, Your Honor.
All right, and I understand we have a bunch of interns this morning. Interns, go ahead, stand up. You didn't think you're going to sit down here for free freight, did you? All right.
Judges, interns, sorry.
And what are you studying?
Probably learn something.
Oh, my name is Salma, and I'm interning for Mr. Jimenez.
Okay, all right. Welcome back. Okay, all right. Madam?
My name is Bassett, and I'm interning for Mrs. Lawson.
Okay.
My name is Nana, and I'm interning for Judge Adams.
Okay, what are you studying?
I'm studying.
Are you in high school or in college or in law school?
High schooler.
Okay, all right. So eventually maybe going to law school one day?
Yes.
Okay, madam?
My name is Naya, and I'm interning with Judge Adams, and I'm in high school.
Okay, wonderful.
Hi, my name is Kelsey. I go to Georgia State, and I'm studying political science.
All right, welcome.
My name is Josie. I'm rising 2L at Georgia State.
Well, welcome. Okay, all right. Okay, thank you very much. Please all be seated. All right, first order of business we're going to take up this morning is the matter of.
Oh, sorry.
the search warrant of Mr. Johnson's computer. Mr. Delphine and counsels who are similarly affected, Mr. Johnson sent us a doctor's note yesterday, which I will mark as the next court exhibit in order, which indicates that he, as you all know, he was involved in a rather serious motor vehicle accident. And his doctor has put him off of work from the 18th of June through the 9th of July. And he anticipates he can return to full duty as of the 10th of July. So that's what we have at this point in time. I also have an email from Mr. Johnson. We sent him an invitation, given his medical, to join us via Zoom. And I'm going to include this as the next court exhibit in order. He sent this just to Mr. Kearns, my staff attorney. We sent a message to him as well as to Mr. Delphine, as is customary for to make sure there's no ex parte communication. He indicates, as Mr. Johnson indicates, that he's got some vision issues, and he's supposed to see a medical provider in about a week or so, next week, I think, and will let us know what his condition is at that point in time. So I'm going to include that as the next court exhibit in order. So I thought that what we would do this morning, counsels, I'm going to do two things. I'm going to introduce you to the special master, Miss Allegra Lawrence Hardy. Madam, good morning.
Good morning, Your Honor.
This is going to be your special master. She is a member of the State Bar of Georgia and consistent with the statute that governs these particular proceedings. She is a member of the Board of Governors. So I am going to just introduce you to her. Madam, if you, between now and the next time, if you and your colleagues would also run a conflict check to make sure that.
So, Your Honor.
Okay. Okay, good.
Okay, for you who don't know, a special master is a court-appointed attorney who is brought in to oversee, rule on pre-trial objections, address pre-trial matters, monitor compliance, stuff like that. And it's quite broad, special master. It's limited only by the judge. So that is what a special master is, in this case at least. Exactly what kind of limitations or what exactly she is appointed for, I'm not sure. I just heard this.
The thing that we'll need to do now, counsels, is I'm going to pick another date for the hearing to be continued to. Mr. Delphine, I don't think you have any objection at this point in time, do you, sir?
No, Judge, I don't. In terms of conflicts, I am out the week of July 15th. I'll be lecturing for the Prosecuting Attorneys Council that week. But other than that, I don't have any conflicts until the end of August.
Okay. Counsels, given Mr. Johnson's, we may end up having to do this a couple of times because given his condition, I don't know whether or not his doctor is going to release him, or he's going to have other issues. But I was going to say we could do this on the 12th of July. Does that work for all of you? Miss Lawrence Hardy?
Yes, Your Honor.
Does that work for you, madam?
It does, Your Honor.
Okay, all right.
It works. It's good for the state judge.
All right, we're going to be in.
Okay, so this is not much unusual, sorry. They have a hearing. Mr. Johnson is one of the defendants in the RICO trial, and they were going to have a hearing about a search warrant of his computer. Some issues, probably, and they have appointed a special master about it, but he went and got himself in a car accident and couldn't attend. So they are postponing it until the 12th of July. And nothing unusual, except this is a RICO trial. So every name you heard being called out, that's all the attorneys that was present, because they need to be there to hear this hearing. So imagine that for the first time in a few weeks, maybe up to a month, everybody is called into the courthouse to hear that it's postponed. That is 1 to 2 hours of these lawyers' time. And it's wasted. Because, yet again, stuff is being postponed in this RICO trial. Thank you, Moon Baby. I adore you, handsome. Oh, thank you so much. Thanks for being stellar. Thank you, thank you, thank you, thank you. So, yeah, that would be the extent of, and thank you for the $2 super chat. Thank you so much. So that is the extent of the one and only hearing we had yesterday. So everything is still in the future. This trial would have started in January. And it's June, end of June. It's solstice. It is midsummer. And I hope, by the way, tomorrow, no, it's Thursday today, Friday, Saturday is my midsummer stream, where we celebrate the summer solstice, the equinox, life, love, everything. So, but let's get back to what we actually were here for. We are here for ADA Skittle. We are here for Prosecutor Love, Officer Shart, and Attorney Shart and Officer Fanny. So let's get back to the Daubert-hearing. Now, the Daubert-hearing is should be pre-trial, but it went long, 7 days. This is still on day 2. This guy, Assistant District Attorney Michael Sprinkle, competent, but there are still some issues. And if you are new in here, this trial is a cluster F. But let's see how this continues.
I accuse recipes in jail for this thing. Oh, so I wouldn't necessarily. I can
Oh, DDA, this Deputy District Attorney Michael Sprinkle. Oh, come on.
At trial. You're aware. Thank you, Your Honor.
There we go. Sorry.
All right, go ahead, sir. I'm sorry. Thank you, Your Honor. May it please the court once again.
We are getting in. Oh, sorry. We are getting into the cross-examination of Deputy District Attorney Michael Sprinkle. And let's see how this goes.
You're aware of the rules of evidence in Georgia?
Yes,
Okay, that dictate what is admissible at trial?
that's correct.
Okay. You are aware that
the rules of evidence are different for a RICO case, correct?
That's correct.
You're aware that typically in a criminal case, quote unquote, bad character evidence is not admissible against a defendant.
With exceptions governed by 404B.
Right. And 404B, propensity evidence would not be admissible under 404B.
No, it's motive, intent, knowledge, plan or scheme, preparation, absence of mistake or opportunity.
You're aware of the fact that my client, Mr. Stillwell, because this is a RICO case, is being tried for 2 murders at the same time, correct?
I am familiar with the second murder from earlier this year, yes.
You're also aware that because this is a RICO case that was indicted in 2022, my client is accused of over a dozen overt acts that are listed in the indictment.
I am generally aware of the format of the indictment. I haven't studied it. If you're telling me that then I'm sure that's true.
Yeah. In a RICO trial, everybody is responsible for each other's crimes. That's the RICO Act of 1970, designed to get to mafia. If that person over there made a crime and that person over there is in the, say, within the mafia, they are both charged with that crime. If there's one crime there and it's 20 other in the mafia over here, all are charged with that specific crime. So that is what this attorney is talking about. That he is being charged. Normally, under normal circumstances, he wouldn't be charged. But since they allege that this is a gang and this is a RICO trial, they can charge him for that as well. And then it's a different set of rules. Yeah, and I thought that it would be lunch time in the other trials today, around noon. But apparently they are still going, so we are not that many in the chat. But I promised you we would start at this time, so we start at this time. And if you're here on the replay crew, don't forget to like this video, please. Thank you.
You would agree that oftentimes, if people are simultaneously accused of 2 separate crimes, they receive different trials for different crimes, correct? Different allegations.
Well, it would depend on if it was, for example, a crime spree based, temporal proximity being very close that the incidents are almost considered one continuous incident, then you may indict them together. But particularly given the length of time between the 2 incidents, you would generally indict them separately, correct?
Okay, so, and you're aware that the other murder that is alleged against my client is from 2022.
Correct.
You would agree that that would not have temporal proximity, correct?
No, I would, if these were just 2 completely independent murders, I would not put the 2015 murder on the same indictment as the 2022 murder. They'd be 2 different murders under normal circumstances.
As a lawyer, can you see where that would be prejudicial against my client?
Well, yes, I suppose if you were to have 2 murders on the indictment, then the jury would be told initially that there was a finding of probable cause on not 1, but 2 different murders. And so I can understand that.
What about evidence being...
I like this Michael Sprinkle. He makes honest answers. No excuses, just honest answers. I like him so far. But we have a long way to go. He's going to be on the stand for quite a while.
presented and discussed about the actions of other
Hi, Matt.
individuals for things that occurred years after 2015, would those typically come in for a murder that happened in 2015?
Well, it would depend. If it was a gang-related murder, maybe. Because, when there's a gang charge that's placed on somebody, then there's a lot more evidence that can come in related to the street gang.
What about if your office decided to indict this 2015 incident in a timely manner and didn't wait till 2022? Would this case have
Objection, Your
already been
Honor.
tried?
Objection as to speculative and argumentative.
I sustain the objection.
He makes a good point, but the objection is
You,
it's good.
through your investigation, did you come across a gentleman by the name of Terman Stillwell?
I did. Yeah, Detective Thorpe and I spoke with him, I believe, in early 2016.
Okay, and Terman Stillwell, who found Terman Stillwell?
I believe it was Detective Thorpe. It wasn't me, so it must have been Detective Thorpe. And I don't recall how he learned about Terman Stillwell.
Ever ask Detective Thorpe about the circumstances on how he found Terman Stillwell?
Objection, Your Honor, as to the relevance.
Yeah, what's the relevance, sir?
I mean, this is the investigation we've been talking about.
Mr. Sprinkle, what's the?
This is the investigation we've been talking about that we admitted this report as part of, and I'm asking about the investigation. I'm cross-examining the investigation.
Oh, the objection. Go ahead, Mr. Sprinkle.
Thank you, Your Honor.
Go ahead and answer it.
So if I remember correctly, he was in the Fulton County Jail. Well, we interviewed him at APD, but he was brought over from the Fulton County Jail. Contemporaneous with his arrest, he told,
Hi, David.
from what I remember, he definitely told somebody with the Atlanta Police Department that he had information on the murder. And if I remember correctly, it was the members of the Apex unit. They may have been the ones that arrested him. But at any rate, he said something to some police officer that he knew something about the murder. That got back to Detective Thorpe. So Detective Thorpe told me about it. And then Detective Thorpe transported him from the Fulton County Jail to APD where we interviewed.
Did you ever talk to the member of the Apex unit to confirm that they were the ones that had first contact with Terman Stillwell?
I don't recall.
And Terman Stillwell, he was in jail for what?
Yep.
Family violence battery, I believe.
Okay, felony?
I don't remember if he was a recidivist or not. It may have been. I just don't remember.
And who was he accused of battering, beating?
I think it was his wife, if I remember
What's her
correctly.
name?
That I don't recall.
Would it be Vanetta Guffey?
That's it.
Okay. And so Mr. Stillwell, Terman Stillwell, let me be clear. Terman Stillwell came to your attention, and did you have an opportunity to speak with Mr. Stillwell?
I did.
And when was this?
March 22nd, 2016.
So we're still back in 2016.
We are.
Okay. And did Mr. Terman Stillwell claim to know my client Shannon Stillwell?
Yes, I believe he said that they were relatives. They were related. Like it was Mr. Stillwell, Terman Stillwell, said he was his cousin, if I remember correctly.
Did you ever confirm that there was any family relation?
Well, apart from their last name being the same, or one of Mr. Stillwell's, Shannon Stillwell's last names, because he was known as either Jackson or Stillwell. I mean, even back in 2016, I knew that was one of his aliases. I was never completely clear as to which name was actually his name, Shannon Jackson or Shannon Stillwell.
Okay, but let's just benefit of the doubt, it's Shannon Stillwell. Did you ever independently, other than they had the same last name, confirm that there was any relation between the two?
I don't remember.
But Terman Stillwell claimed that he was Shannon's uncle.
I thought it was cousin.
Cousin, okay.
Yes.
And Terman Stillwell was in jail at the time that he met with you guys, correct? I know that you brought him over to APD headquarters, but he had pending charges.
That's correct.
Okay. And he gave you some information he claimed could be used against Shannon Stillwell.
That is correct.
Okay. And he claimed that back in 2015, Shannon Stillwell ran up to him while he was walking with his wife in the park.
That is correct.
Did he indicate which park?
I don't recall the park. I just recall it being August, or it was sometime during the fall of 2015 that Termon Stillwell, as he strolled through the park with his wife, Miss Guffey, he came upon Shannon Stillwell, who complained of getting shot at some point in the very recent past, and that the reason for this was that he had participated in the murder of Donovan Thomas.
Okay, and according to Mr. Stillwell, according to Termon Stillwell, Shannon Stillwell said that Kenneth Copeland, the state's witness, was also involved.
That I don't, yeah, actually, I think he did say that now that you mentioned it. Mhm, yes.
And
Everybody snitching.
if Termon Stillwell was to be believed, that would be a confession coming out of Shannon Stillwell's mouth.
A third-party confession, yes, sir.
Okay. And of course, as we saw with Mr. Wright, Mr. Stillwell, Termon Stillwell, had pending charges at this time.
He did.
And as an investigator, you wanted to corroborate what Termon Stillwell.
And I'm already in the yellow. I'm ads, not suitable for ads. Yeah. Welcome to my world, where this testimony, according to YouTube, is, oh, this is highly, highly not suitable for ads. But then again, yeah, it's just getting used to. In a few days, I will ask for a review, and in 2 weeks, it will be removed. And yes, you are suitable for ads. Yeah, but by then, most of my audience will already have seen it, and I will have made 12 cents on this video. Welcome to my world. Just a quick recap. District Attorney Sprinkle was involved in the investigation of a murder that took place in 2015. There were 5 suspects, but he never brought it to a grand jury because there were literally no evidence to bring forward to a grand jury. And here we are at the RICO trial, where they still bring up that 2015 murder because they can under the RICO Act, even though nobody was charged. Yay. But this deputy district attorney has been very, very honest. I like his testimony.
Stillwell was claiming that he had witnessed.
That's correct.
And you were also aware that there were many street rumors going around at that time.
There were, yes.
Okay. So you sought to corroborate the statement of Termon Stillwell.
That is correct.
And you decided to call in Miss Vanetta Guffey to talk to her about the situation, correct?
That is correct.
Okay. And speaking of Vanetta Guffey was important because she was the person
yellow.
that
But,
Termon
thank you.
Stillwell claimed was his wife.
That's correct.
I'm
And
wearing
that Termon Stillwell was claimed was present when Shannon Stillwell supposedly made this statement, correct?
That is correct.
Okay. And you were able to speak with Miss Vanetta Guffey, correct?
Yes, I believe, I definitely remember speaking with some female after that Termon Stillwell interview, and it was related to that interview, and it didn't go very well.
Okay, now, Mr. Sprinkle, I want you to know that I have no objection, of course, subject to the judge's rulings, to you referring to your notes to answer these questions.
I'm actually referring to the Exhibit 11 to.
Your report.
Right.
Right, and I have no objection to that at all. I want,
Okay.
so we're clear on this. What page are you on?
Oh, well, the pages aren't numbered, but I'm on the page that starts with on May 11, 26. Oh, well, it just so happens I'm on the right page.
All right, cool.
All right, so it was on May 11, 2016 when Detective Thorpe and I interviewed Vanetta Guffey on the 7th floor of my office, the DA's office.
Okay. And you said it was you and who that interviewed her?
Detective Thorpe, Jim Thorpe Jr. with the Atlanta Police Department.
If you have social media, please share this stream with more people. That would be much appreciated. Thank you.
And how did you get Miss Guffey to come to your office?
I don't recall. I believe if I had to, hold on, let me see.
Did you tell her it was about Termon Stillwell's case about him beating her?
I believe so. That sounds right.
Okay, so is it, and I'm not suggesting it's illegal for you to do this, but you misled her about why you wanted to speak.
Well, I mean, as a practical matter, I mean, that it was a legitimate area of inquiry as well. She was a victim on a case, but, you know, we didn't want to tell her about the murder because she didn't even know that she was part of the murder investigation yet. So to get her into the office, we thought it would be better to just not tell her about that part and rather just tell her about the case in which she already knew she was a witness.
Okay, fair enough. And you eventually told her you wanted to speak to her about this case.
That's correct.
And did you tell her that Termon had said that she may have witnessed something?
I did.
Do you remember exactly how you worded it? I shouldn't say exactly. Can you paraphrase how you worded it if you don't remember exactly?
I asked her about Shannon and asked her if she knew of Shannon. She said that she did, that she considered him her little nephew. And she also said she wasn't fond
you can
of
listen to
Termon
this
Stillwell
while I go
because
get another beer.
going back to the case in which she was a victim because of him beating on her. At the time of the interview, Mr. Termon Stillwell was still in the Fulton County Jail. All I remember is that when we brought up Shannon, her mood, she was relatively pleasant at the beginning of the interview. And, you know, after we discussed the battery and moved on to Shannon, she was, her mood changed. Shannon Stillwell, your client, her mood changed rather dramatically. In fact, it culminated in her storming out of the room and basically running out of the office.
Right. And she made it clear to you that you shouldn't believe a word that Termon Stillwell says.
She called him a liar.
Right.
She, as she stormed out, I believe she called him a liar.
He's unreliable.
Right. That's what she said.
And you don't dispute that Miss Guffey knows Mr. Termon Stillwell very well.
No, she knew him pretty well. She was a victim on a family violence battery case, so you have to know somebody pretty well to be considered a victim of a family violence offense.
Okay.
Mr. Shart, before you pose your next question, how much longer do you think you'll have?
I was about to ask like 3 more questions.
Oh.
Unlike Mr. Menendez, I think I'm being...
Who's 2 is not really 2?
Right.
Okay, all right. Okay, well, I'll be the judge of that, okay? This is number 1 coming up right here, okay?
Pressure on. Mr. Sprinkle, did Miss Guffey indicate to you that she was not...
Not
Did
much.
she ever
Not
indicate
much.
to you that she had heard Shannon Stillwell say anything about a murder?
No. Without even refreshing my recollection, I mean, the interview ended pretty abruptly after she realized that we were asking about Shannon Stillwell. It wouldn't have even got... She was no longer participating in the interview, essentially. Towards the end, I was trying to ask her questions as she ran away from me, so...
She told you that she doesn't know anything about the statement that Shannon Stillwell allegedly made to Termon Stillwell.
That's correct.
That Termon Stillwell claimed that she witnessed.
That's correct.
Okay. Are you aware of where Miss Vanetta Guffey is now?
Well, I've been told, and this I haven't independently verified it, but as of yesterday, it's my understanding she's deceased.
Okay.
She didn't die yesterday. I learned about it yesterday.
Right. I beg the court's indulgence, just briefly.
Okay, so they are interviewing him about interviews he made back in 2016 about a murder that this attorney's client is supposed to have been involved in. And apparently the witness that he
Mr.
interviewed,
Sprinkle,
we learned yesterday, had
As part of your
passed.
investigations, do you stay abreast to what's going on at 901 Rice Street?
Well, yes, particularly with respect to the jail calls.
Okay. Are you aware that there have been multiple attacks on my client, Shannon Stillwell, since, and when I say attacks, stabbings, he's been incarcerated this year?
This year?
Yes.
No, I wasn't aware of
Are
that.
you aware of multiple attacks on Shannon Stillwell while he's been incarcerated?
No,
Objection, Your Honor, as to relevance,
It's,
as to whether or not the defendant has been
prejudice.
attacked.
he's been incarcerated for a long time, and it's certainly relevant that he's
It
being
is.
attacked.
I'll overrule the objection.
I remember a time in late 2015, which would have been around the time he was arrested. He was actually a witness on a murder case.
Stillwell's cousin's wife.
And
Okay.
he was in the same area of the jail as some rival gang members. That's about all. And that there was an issue with that, but that's about all I remember. I don't remember anything about him being attacked.
Are you aware that he's on 23-hour lockdown for his own safety at this time?
No, I didn't know about
Okay.
that.
I don't have anything else, Your Honor. Thank you. Thank you, Mr. Sprinkle.
Madam, Ms. Love,
Thank you, Judge.
it's about 1:30. Can we take a comfort lunch lunch break to 2:15? And then we'll resume at that point in time, okay?
Thank you, Your Honor.
All right. We're going to be recessed until 2:15, and we'll come back at that point in time.
Okay. Let's bring it forward. Dun, dun, dun. That's a long. I have sound on. So this is the feed from Law and C-Word. There.
Anybody else ask questions? Wait after the redirect?
Judge.
For real? Let me let her finish, and then I'll let you all cross as you see fit. Let her redirect, okay? All right, no problem. All right,
Thank you, Your Honor.
go ahead, ma'am.
Deputy Sprinkle. On cross-examination, you were asked,
Oh,
specifically,
it seems like
About
Jeff's
to
viewers are on the
delay
way
this
in.
case to gain a tactical advantage. Were you ever instructed to
Nice.
delay this case
Thank you,
in
Jeff.
any way to gain a tactical advantage?
No, not at all.
You were also asked on cross-examination about the date that the defendant, Shannon Stillwell, was arrested for the homicide or the murder of Donovan Thomas. At the time that the defendant was arrested, on October the 27th, 2015, was the defendant also arrested for July 15th, 2015, possession of a firearm during the commission of a felony, criminal use of a firearm with an...
Now there's a lot of people here. Quick recap. This is the Young Thug RICO case Daubert-hearing. Young Thug is a part of the YSL gang, Young Slime Life. And this trial has been postponed since January. It should have started in January. There's a lot of effery going on. We have had a medical examiner who doesn't follow a standard operational procedure. And when she writes a final report, she only puts in the notes she thinks are useful. And then she doesn't save the rest. And after that, we had a few other so-called expert witnesses who more or less gave nothing. Thank you, Jeff. Hello, all from Jeff's stream. Good to see you. And then we had the state wanted him in state expert witness. They wanted in as a forensic video enhancement expert. But during the interview, we found out that what he does is he takes the video, he makes a screenshot, puts it in Photoshop, and then do pinch and zoom. Yes, zoom and enhance. Exactly. That's so the state still wanted him in as a forensic video analyst, but the judge only allowed him in as a video enhancer expert. And today we are watching Deputy District Attorney Michael Sprinkle on the stand. He has been interviewed for direct interview for over an hour. Then it was cross. And he is there because he was involved in the 2015 murder where there were 5 suspects, but he did not find enough evidence to even bring it to a grand jury. But since this is a RICO case, the state has chosen to bring these allegations in anyway, which they apparently can under the RICO Act. And you know what? I'm going to send Jeff a link if he wants to participate. And I'm also going to send to Chandler if she wants to join in. So this is where we are. He is being interviewed. I like this deputy district attorney a lot. He has been very honest with everything in this. Very, very honest. Which is almost surprising because nothing, in my opinion, this is Prosecutor Love, by the way. So in this Daubert hearing we are watching today, there has been, and last time we went into this, there has been Prosecutor Love, DDA Sprinkle, we have an attorney Shart, and we have an officer Fanny. And if you are British, that is very funny. And so this questioning now has been regarding the 2015 murders and why or why not. Let's see. See this. What is a Daubert hearing? A Daubert hearing is something that is pre-trial where everybody has a chance to interview the experts the prosecution wants to bring forward in the actual trial. Yes, Mrs. K. Griff, those are actual names. and yeah, it's funny. It's funny. Hi, Peace Peony. Good to see you all. Good to see you all. Don't forget to like and subscribe. But let's continue with this. He has been cross-examined. Now it's redirect. then, because this RICO trial, I have to say, from the beginning, it was 28 defendants. 28. 6 months later, they're down to 11 defendants. 8 people have taken plea deals in exchange for testimony in the upcoming trial. On top of that, there are still people in this, among the defendants, who still doesn't have representation. Because the state said, we are bringing all these 28 people in. There's not enough lawyers in the public defender's office, so they are hiring private lawyers. But they will only pay $15,000 for the entirety of this case. And so far, it's a year-long process. The trial hasn't even started yet. And the trial is maybe 6-month long trial. Let's see. Hello, David at MLS Law Show. Yes, they will usually go through the qualifications in front of the jury as well, because prosecutors like the jury to hear their experts' qualification, but this is an evidentiary issue. So that's what Daubert hearings are for. 6-month trial. Yeah. So I really put on a big responsibility because I will be covering it. Yeah. And the trial hasn't even started yet. They haven't even finished getting a jury. So it can begin next week. It can begin next month. It can begin next year. So that is why I, among other things, with David, we are catching on to we are rewatching the Jodi Arias trial. On Sundays, I'm doing a serial killer Sunday, where we now are watching the Jeffrey Dahmer trial, the entirety of the Jeffrey Dahmer trial. So if you are not a fan of hearing in detail what Jeffrey Dahmer did, that stream is not for you. But if you're curious, tune in on Sunday. Okay, now you are all up to speed. Let's continue with Prosecutor Love.
Altered identification mark and possession.
I'll stay in this form. Go ahead and just reform the question now.
At the time that the defendant was arrested for the murder of Donovan Thomas, was the defendant arrested for other charges as well?
Yes, it was not just the murder for which he was arrested in October of 2015.
And while in jail on those other charges, did the defendant enter a plea on those other charges?
Well, I don't know exactly what happened. I know that he was convicted of those other charges and sent to the Georgia Department of Corrections. I believe he entered a plea.
Fair enough. And so during the time that the defendant was initially in jail for the murder of Donovan Thomas, he was convicted, is that what you're saying, of charges unrelated to Donovan Thomas?
That's what I'm saying, yes.
And was he then sent to the Georgia Department of Corrections or prison as a result of that conviction?
Yes.
Yes, Wolfram.
The exact 250-something days after his incarceration on October 27, 2015, he was sent to the Georgia Department of Corrections.
And what?
Oh, yes. Hello, I am Nick Starow. This is Nick Starow's Trial Watch. I'm Swedish. I'm a union rep. I do labor law. And you might have seen me on Jeff's stream on a couple of occasions. You might have seen me on David's stream and other people's streams. Sometimes there's alcohol. And if Let's Go Brandon is around, things get weird. Okay. Stig Wasny. Daubert standard of admissibility of witness testimony. Expert's testimony is relevant to the task at hand and that it rests on a reliable foundation. Thank you, Thank you, Gosney. Okay. Let's continue.
Was the defendant given credit on his sentence for those unrelated charges to the Donovan Thomas murder, for those 200 and some odd days that he spent in the Fulton County Jail?
Are you asking, did he get credit for time served?
Yes.
I mean, I can presume, but without the actual sentence, I can't say for sure.
Okay. Just one moment, Your Honor.
Yes, and this was the issue with the pinch and zoom guy. He had never been peer reviewed. He's, according to his own testimony, he has never even been reviewed. He has never taken a class at forensic video enhancement. Nothing. He's a pinch and zoom guy. He did video enhancement in the 80s and 90s. He learned it on VCR tapes, but he hasn't updated himself. So he uses Photoshop by taking a screenshot, putting it in Photoshop, and pinch and zoom. That's the extent. And he still was allowed in as a state's expert at video enhancing.
And Your Honor, I would ask that the court take note of the final defendant disposition filed in case 15-SC-140132. Take judicial notice of that, as it is a part of the clerk's record in Odyssey, as well as
the long link
the affidavit of the
on top of the
custodian
chat.
in that same case, 15-SC-140132.
Thank you, Steve Gosney, for educating
filed
us.
April 12, 2016, as well as jail booking for booking number 1521859. Deputy Sprinkle, after the defendant's prison sentence, Fulton County Jail on or about October the 23rd of 2018.
He was, and then he bonded out the next day.
And was that one full day that the defendant spent in jail from October 24th, from October the 23rd, 2018 to October the 24th of 2018, the one day that the defendant spent in jail for no reason other than the murder of Donovan Thomas?
Yes, that sounds correct. And I don't know if it was 24 hours or it was 8 hours or 3 hours. It was within a day he was released.
This is Law and Seward's feed that is
After
jumping.
you spoke
It's not
with,
my.
Vanetta Guffey, do you recall being asked about that on cross-examination?
I recall being asked about Miss Vanetta Guffey.
Okay.
Yeah, and by the way, if you doesn't he look like someone? Yeah, doesn't he? Let's get back to the hearing.
During your conversation with Vanetta Guffey, you were asked on cross-examination whether she explained, whether you all told her rather that you wanted to speak with her regarding a domestic violence incident. Do you recall that?
That's right. She was She was the listed victim on a domestic violence, family violence battery case with, I believe it was her husband, Tremont Stillwell.
And during the conversation that you all had with Ms. Guffey, in the time that you sat down with her, did Detective Thorpe ask her if she is familiar with the defendant?
Either he did or I did, yes.
And did she acknowledge that she was familiar with him?
Yes, she said that he was, I believe I'm quoting directly or exactly, like her little nephew.
And did Detective Thorpe pull out a photographic lineup containing an image of the defendant and begin to read a lineup admonition?
She did, or he did. Yes, he did.
What did Ms. Guffey respond, or how did she respond near the end of that recitation of the lineup admonition?
Well, I mean, I can quote her. She said, "But what is this in regard to with Shannon? Before we can start anything, if this isn't dealing with my ex-husband, I don't even want to be here because I don't deal with Shannon like that."
Okay.
So she cut him off.
And did Detective Thorpe tell Ms. Guffey that?
I don't know. Does it look like Tobey Maguire or Baggins? I know the names in this trial is amazing.
Tremont Stillwell had said she was present when. John, did Detective Thorpe respond with anything in particular after Ms. Guffey made that comment?
Yes, he said that Tremont Stillwell, her ex-husband, told both he and I that she was present when Mr. Shannon Stillwell, or Shannon Jackson, confessed to, quote unquote, a crime.
Prior to that point, did you or Detective Thorpe mention that the crime, or suggest that the crime was a murder?
I don't believe so. I mean, I audio recorded the interview, and just looking at my notes, which is a summary of the interview, I just characterized and I quoted Detective Thorpe directly when he said a crime. So going by that and my recollection, I would say no.
Despite the name, and we might make fun of it, this guy, I like him.
Was it at that point that Ms. Guffey ended the conversation?
Well, yeah, she scoffed at at Detective Thorpe's assertion that Tremont Stillwell, her ex-husband, had said that she was present while Shannon Stillwell confessed to a crime. She said that she wasn't around him like that, essentially, and then she said he was a liar, and I think it was around that time she...
He's a liar.
That'd be Tremont Stillwell.
Okay, all right, thank you.
And did Ms. Guffey indicate that Tremont Stillwell did not deal with Shannon Stillwell?
Now you're leading.
Well, I know...
What did Ms. Guffey then say about Mr. Stillwell, that is Tremont Stillwell's relationship with Shannon Stillwell?
Okay, I'll just quote her directly. She said, Tremont Stillwell is a fucking liar and I'm ready to leave. So that's a lie. He don't even deal with him. I told him that was his cousin. He don't even deal with him. And then she went on to say, whatever Shannon did, that's on Shannon. I don't have anything to do with that. Thank you.
What did she then do?
Okay. YouTube, that wasn't me. That was in the trial. He's reading from a transcript.
She got up and Hurley walked out of the room. We followed her. Detective Thorpe and I did. I continued to audio record my interaction. She uttered something that I wasn't able to understand, but it ended with nothing about a homicide. She just...
Do you think that that was significant?
I thought it was somewhat significant because we hadn't said anything about a homicide.
And Did you hear any more utterings by Ms. Guffey as she neared the elevator?
Yes, I followed her outside. She called someone on her phone and she said, quote, "Girl, come get me out from down here. They're talking about a homicide." And
At that point, had either you or Detective Thorpe mentioned anything about a homicide?
no,
And did you hear Ms. Guffey tell the called party anything else about Shannon Stillwell?
well, just as the elevator door closed, she said that the questioning concerning this homicide dealt with quote unquote Shannon, and that she quote didn't deal with Shannon like that, end quote.
And did you capture the entirety of that interaction on your pocket voice recorder
I did.
and make it a part of your investigative case file?
Yes.
Ladies and gentlemen, not legal advice. Don't talk. Especially not inside the Deputy District Attorney office. And whatever you say might and will be recorded and played out in court or read out in court. General advice, not legal advice. Thank you, Alphabet Side Effect.
Why is it that you're not mentioning anything about a homicide made Ms. Guffey's words significant to you?
Well, we hadn't told her about what kind.
I stand the objection.
And if I can grift a bit, if you want to support the channel, become a member. Join the Vikings Saying Hi squad. That's $3 a month, and it helps me plan ahead on what to do to improve the channel with sound, video, lighting. Might be needing a bit of improvement. Yep. So that is what memberships will, and there's members only stuff in there as well. Today I had a poll on I'm going to the liquor store. What should I buy? And it became a bottle, 2 bottles of whiskeys and a bottle of vodka, according to my members. So on Saturday on my midsummer stream, oh hell yeah.
I think he's already mentioned it anyways. It was significant.
fine.
Yes.
Significant
Check
because
if you're
of
still
he didn't say anything about the homicide investigations.
Thank you, Your Honor. One more moment, if you will, please.
While you're doing that, Mr.
And this is still Law and Seaward's feed that is having a hiccup. Yes, if you believe you're already subbed, just check and see if you actually are subbed. YouTube sometimes kick people out.
Thank you, Your Honor. That's
Okay.
all that I have. Thank
All
you.
right.
Mr. Sprinkle.
Yes.
Hey,
Okay. That was the redirect on the first cross of this witness. Now, next cross, because there are currently, I believe, 12 attorneys in this courtroom. I don't know if everybody will cross him, but some of them might do it.
ADA Love was just asking you about Vanetta Guffey mentioning a homicide, correct?
Yes, that's correct.
And she's making a point that you never mentioned homicide.
That's correct.
Okay. Now, we're aware that there were many street rumors going around at that time.
Yes, from my review of, for example, Instagram at around that time, certainly there were many. I don't think it's a mystery that there were a lot of rumors going around about concerning the murder at that time.
And so there could have been many ways that Vanetta Guffey could associate Shannon Stillwell with a quote homicide.
Yes, it wasn't a top secret government secret, so to speak.
Mr. Springer,
I
how
like
would you
this
suggest
district attorney.
we get inside Miss Guffey's head and figure out how she knew about homicide?
Well, clearly we wouldn't be able to do something like that. The technology doesn't allow for it.
Well, what would we do?
Cause for speculation. The question, form the question.
Can we, well, when you want to know what's going in someone's head, is there a way that you could inquire?
Well, yes, you could ask them, but of course, Miss Guffey, we can't ask now because she is deceased.
Oh, so what?
Yes, this witness was one of the defendants in this trial, besides Young Thug, is a Mr. Stillwell. Now, there are some questions if the other this is the uncle or cousin. The person they are questioning him about is the other Stillwell's wife. And the witness learned yesterday that she passed away some time ago. So the witness testimony will not be refuted by this witness because she's deceased. So we don't know if this will ever enter the actual trial. So this is an inquiry about the investigation.
We're talking about, we can't inquire about what was going on in Miss Guffey's source of knowledge because she's unavailable.
Thank you, Gigi.
She is unavailable now, and based on my interaction, whether I don't believe she was interested in answering any more of my questions at any rate. But now it's of course an impossibility because she's dead.
And she's unavailable to the defense as well.
I'm sorry.
She's unavailable to the defense as well.
She's unavailable to everyone, assuming that my information is correct, that she is in fact deceased. That's what I was told yesterday.
Okay, and she passed during the pendency. I know you don't know the exact date, and that will be tendered into evidence, but she passed during the pendency of this case, is your understanding?
If she died between the date that I interviewed her and today, then that would be during the pendency of the case.
Okay. One more thing, you asked if anyone instructed you not to indict the case to gain a tactical advantage, correct?
That's right. Yeah, that was never ever part of our
But
conversation.
again, you're not the one who decides when to indict the case, correct?
No, I'm not.
Okay. All right, thank you.
All right. Mr. Jimenez? Cross?
And here comes the next lawyer.
As the person who's going to make the legal argument, may I make a short argument to the court?
Sure.
Oh, this Daubert-hearing was 5 months ago. So we are going through it in preparation for the actual trial. And we still haven't gotten to the parts where a lawyer is being accused of handling drugs in the courtroom. We still haven't gotten to a part where in the jury selection that first occurred 4 months ago, where a jury was sent to jail because she filmed in the courtroom. Yeah, and we still haven't gotten to the part where different lawyers were deemed in contempt of court and was told to write 20-page essay on how to conduct themselves in court and being forced to buy lunch for their colleagues because of contempt of court. So we still haven't gotten to these parts in these Daubert hearings and the first round of jury selection. This trial will be amazing to follow because holy crap, it will be entertaining. So we will, filmed in jury selection. Yeah, so this trial will be entertaining AF.
This is the defendant Stillwell's most.
One of the attorneys were accused of handling drugs, prescription pills in the courtroom without permission. And I've heard in the chat, I haven't seen it, there is supposedly also a drug exchange in the courtroom. But I want to see it live. I don't want to find out too much about this.
For constitutional speedy, that is his personal right. Now, the evidence
So far,
that we
yeah.
introduced at trial will be introduced against all of them unless there's limiting instruction because of the RICO count. However, the issue on whether one individual's constitutional speedy rights were violated is specific to him and does not apply to anyone else. And so there's no motion currently before which any cross-examination by any other particular defendant's attorney would be at all relevant, and there'd be basically this is
Not that I
testimony
heard of.
relevant to his and his motion only, Mr. Stillwell's. And so we would object to having anybody else cross-examine Mr. Sprinkle only because it is not relevant to the issue that is before the court.
Okay.
I learned from an interview from the lead attorney, the YouTuber, that they are paying a grand total of $15,000. And according to him, one of the attorneys opened an OnlyFans account to fund, yeah, because $15,000 for a lawyer for the grand total of this trial is not enough. Is it true there is high drug use in the lawyer community? No comment. And I am in Sweden. I'm not daytime drinking. It's 7:15 p.m. here.
All right. Thank you, sir. Go ahead.
Thank you. Good afternoon, Mr. Sprinkle. How are you?
Very well. How are you?
Sudi Chakaman on behalf of Mr. Doshi. I just want to go through this as quickly as
I'm not
possible.
sure.
Everybody has
This
things to do.
trial has
Let's focus
everything.
on the timeline. I'm interested in the timeline. When did the murder happen?
January 10th, 2015.
All right. So in 2015, that's when the investigation happens. And then when is Stillwell arrested?
October 27th, 2015, if I remember correctly. It was definitely towards the end of October 2015.
When did you get a chance to talk to Mr. Wright?
That would have been January of 2016. Matter of fact, I believe I can actually give you them refreshing my recollection. It'd be January 12th, 2016.
And Mr. Wright had been arrested and taken to the Atlanta City Jail. Is that right?
He'd been sitting in the Atlanta City Jail since October 2015. That's correct.
Now, he was in the city jail on misdemeanor or felony charges?
I believe it was felony charges, a felony probation violation warrant, perhaps. He also had that gun. Maybe he was charged with that, but his charges were it was within the jurisdiction of the Superior Court.
I need to have that
do you
something
remember,
similar
is it
for
accurate
my
to say that
casual
when he was
streams.
arrested, he actually did not see a judge within 72 hours? Do you remember that?
Objection, Your Honor. As to-
Now we're going to.
Okay. I'll
Move on to
move on
something
on.
else.
You testified during direct that you had a chance to listen to a call by Mr. Wright. Is that right?
I did. Yeah, that was the jail call that he placed to his friend shortly after his arrest. Jaquise Smalls is actually the friend's name. I didn't remember it on during Mr. Shart's cross-examination, but that's who it was.
And after
Yes, there's attorney Shart in this trial. Hi, Chandler. I sent you a link on Twitter if you want to come on. But yeah, there's an Prosecutor Love. On the stand is DDA Sprinkle. There's an Officer Fanny. And there's attorney Shart. So yeah, this trial has everything. Okay, Chandler can't be on because she's working. It's horrible. You all need to go to Chandler Remington's channel, subscribe to her, get her every hour, like everything she has done, so she can do this at least more often.
after you heard that call, did you know that it was him? Did you recognize his voice when you heard that call?
Mr. Wright?
Yes.
Well, at that point, I had interviewed him, so I was familiar with his voice. This was going back a little bit. I'm going to go ahead and say I must have recognized his voice.
Is it fair to say you recognize his voice because you had interviewed him in person before?
Yes.
I'm going to object as to the relevance.
Now, what's the relevance of this, sir?
We're trying to see if that is.
Does it have anything to do with your client, though? Because remember, even though statements, I'll give you wide latitude if you're trying to cross as to statements that might be attributable or relevant to your client.
Yes, Your Honor.
Let's kind of focus and narrow it.
I'll move along.
All right.
Thank you, Your Honor. After you spoke with him, then you wanted to verify that whatever he was saying was true. Is that right?
Well, if we're speaking about Mr. Wright, I was verifying that what he had said previously to the police was actually not true. And I was trying to confirm that this person had essentially made everything up.
Okay. And you had access to the video.
I did.
And then when you watch the video, whatever this person claims that happened, whatever Mr. Wright claims that he saw, it would have been impossible because he's not seen on the video. Is that right?
Yes. In this 2015 murder, they had a witness who claimed that he saw these people do it. But Mr. Sprinkle checked video where this witness is supposed to be standing, a surveillance video. He said that he was in a bus stop, and he wasn't. The only thing shown in that video was a cat. And unless the witness is a cat at night, he didn't see it.
That's right. He said he was at the bus stop. I believe he said he was standing there listening to an iPod or something to that effect. And he was very specific. But then when I showed him the video, I said, there's nobody standing there, and he didn't have a satisfactory explanation.
Once more, Mr. Dorsey is not charged.
I sustain the objection.
This happened, all of these interactions were happening around 2016, correct?
Maybe it will be shown
yes.
in
You testified a little bit
when the
about how
actual
there's
trial.
been changes in leadership at the office. Is that right?
That's correct.
There's been at least 3 other people that were heads of the gang unit since this happened. Is that right?
That sounds about right. Yeah, it was Adrian Love, Kara Combry, and then Chris Sperry was the current head of the gang unit. Gabe Banks was the head of the gang unit when all this happened back in 2015.
Ultimately, can you tell us with some degree of certainty?
Hold on. What was the name of the head of the gang unit?
That sounds about right. Yeah, it was Adrian Love, Kara Combry, and then Chris Sperry was the current head of the gang unit.
Okay.
Gabe Banks was the head of the gang unit when all this
Kate
happened
Banks
back in 2015.
was the head. So we have
Ultimately, can you tell us with some degree of certainty
Officer.
what time did you
We have another name. We have Banks, Fanny, Shart, Sprinkle, Love. This will be amazing to follow this trial. I don't care if it's a 6-month trial that I'll be occupying myself with. I really hope everything of these. I have high hopes for this trial. It is a cluster F.
determine you had enough evidence to go forward on this count? And
Listen to him
including
while
on
I
the
go
RICO
grab
count
another beer.
for Mr. Stillwell as well as his co-defendants.
What time did I independently figure that out?
Yes,
That we
what
had
time
to-
do you?
Well, I think that around the end of 2018, we could have pursued an indictment.
Okay.
Not against Antonio Sledge, Kenneth Copeland, Demiki, and Garlington, but against the people that are currently charged with the murder. But I know that a lot was done after that, particularly in 2021. There's a wiretap, et cetera. And I also know that there's a difference between probable cause and beyond a reasonable doubt. So probable cause, of course, is the standard that we would need to secure an indictment. So if I'm being honest, which I must be as I'm on the stand, I would say by November
Thank you, Chandler.
2018, we had enough evidence to pursue
Thank
a
you
murder
so much.
indictment. For probable cause, we have probable cause, I should say, not necessarily that we had enough to get a conviction.
Okay.
We could have obtained an indictment.
No, let some other people, okay, at this point, okay? All right, anybody else?
Thank you, Your Honor.
Okay. Just wait, Mr. Shart. Okay, anybody else?
Wait
Going
with the
once,
shot.
going- Wait, Mr. Shart, how about it?
Mr.
Hey,
When
Meepers.
you said
Good
November
to see you.
2018, you were speaking about all 5 charged individuals, correct?
Does he
Yes,
look like a
we would
Mr.
have
Shart?
had- I think we
I
would have
don't
had
know.
probable cause in November of 2018.
And you would agree that probable cause against Mr. Stillwell individually existed well before that date?
We could, well, and, okay, so to your question, January 2016, what did we have? We had Quindarius Zachary's third-party confession against him. That's really about all we had in January 2016, and he was a co-conspirator, fellow
Sheep year.
gang member. I would be, I don't know what the grand jury would have done if we'd presented that.
It is currently very sunny, and it's currently 34 degrees Celsius in the sun that is pouring into my through my window, and that is roughly 93 degrees. So yeah, cheap light beer. Not that light beer. I don't think that beer. This is premium lager.
We have presented that evidence to them. Certainly, there was some evidence that third-party confession.
with your Nick Porcelain Thunder.
You also had Kenneth
I
Copeland's
thought you would
statement
like the
to,
name.
Investigator Gaither and Dennis.
Just to be, this is Law and Seawards feed
obtained
that
this
is
evidence
has a
from
hiccup.
Tremont Stillwell,
That would have been after January 2016, but yes, I did.
but that would have been before November. When
That was March of 2016, the interview with Tremont Stillwell.
2000,
It's not a bright idea to move around
person
cinder blocks in this
claiming,
weather. This is the Law and Seaward feed. You see, I have
that you could have taken as the
plenty of buffering
Yes.
ahead, or what's it called?
All right, anything further, madam?
No, Your Honor, thank you.
All right. I mean, Mr. Sprinkle be permanently temporarily excused at this point in time for purposes of this motion.
Yes, Judge, thank you very
All
much.
right, Mr. Sprinkle, sir, I'm gonna go ahead and excuse you as a witness at this point in time. Don't discuss your testimony, anybody except your changed in this case, okay?
Yes, Your Honor.
All right, thank you, sir.
Okay. The interview with Mr. Sprinkle is done.
All right.
Let's see who the next one is.
Okay, all right. Let me do this correctly. State have anything further in regards to evidence
No,
on this particular motion? The
no, Your Honor, thank you.
Okay, motion is dismissed. All right, okay.
in Your Honor, I'm sure you should say, Defense Exhibit 1 is a certified death certificate of Benedict Guffey, who passed on 7/14/2021.
Okay. Any objections to D1?
No, Your Honor.
All right, D1's admitted.
I have D2, which I guess I could ask that you take judicial notice of, but I've marked it as D2. It's a motion for constitutional speedy trial filed on behalf of Mr. Shannon Jackson, AKA Shannon Stillwell, under the unindicted case number for this case, 15 CP 155.
This guy is Attorney Shart.
Dated July 2nd,
District Attorney Michael
2019.
Sprinkle just left the witness box.
All right. Any objection to the court taking judicial notice of that?
No, Your Honor, I was going to bring this
that
to
and-
the court's attention.
Okay, all right.
Fanny in
D2's
UK
admitted.
is the
Well, I'll
front
consider
end
it
of
for
the
purposes of the motion.
yeah.
Anything else?
Yes, Your Honor, I would ask that you just do, as you did with the state. just-
I'm sorry, one more time?
I'm sorry.
You guys speak in the microphone so
Yes.
everybody can hear you.
Yes. I would ask that you take into judicial notice, as you did for the state, to the fact that in this case, 2 additional constitutional speedies have been filed for Mr.
I
Stillwell.
have 4 sisters.
One
Please
on May 9th of
put
2022.
everything done
under this
down
indictment
when you're
number,
done.
And one on August 5th, 2022, under excuse me, on September 30th, 2022, the constitutional speedy was filed, excuse me for that, and then an amended constitutional speedy was filed as well, Your Honor.
I'll take judicial notice of those two.
And I would also ask Your Honor to take judicial notice of the standing order from Judge Brasher and also
The
the
name
Supreme Court of Georgia.
Fanny is
that,
also, eller Fanny
No
in
statutory
Sweden is also
speedies have any
a woman's
effect
name.
until January 1st of 2023.
Okay, do you have copies of those that you'd like to add for purposes
No
of
comment.
record?
I can
No
supplement
comments.
the record if Your Honor will allow me. I don't have those printed out at this exact moment.
All right, I'll take judicial notice of the standing order issued by the former Chief Judge Christopher S. Brasher, as well as the standing order issued by our Supreme Court of Georgia in regards to speedy trial demands and tolling thereof. Okay, anything else?
As far as evidence, no.
Okay, all right, argument?
I do have argument.
Go ahead.
I'm the movement. I'm the movement.
Yes, you are.
I would waive my opening if I'm allowed to give a closing after the statement.
But it doesn't kind of work that way on this particular issue.
Okay.
You need to go ahead and walk through those particular factors that that in terms of okay, so you were dealing with the bar. I mean, just to give you kind of like a framework, and you certainly are very experienced as to this. One second, young man in the back over there in the tie. Could you please get rid of your gum? No, your turn around. Yeah, get rid of your gum. Don't swallow it and bring personal injury to yourself. Okay, and don't stick it underneath my seats. All right, Mr. Harvey. How come you didn't tell him that that was one of my verboten rules?
I was watching the.
Obviously, okay, all right. So under
Chewing tobacco.
so that's even worse. Under Barker versus Wingo 407 US 415, and in the doggett, there are four factors that I have to consider, okay, in deciding this. Factor number one is the length of the delay. Two, the reasons for it. Three, the defendant's assertion of his right to a speedy trial. And four, the prejudice to the defendant. And of course, I have to go ahead and look at that. And then the threshold, of course, issue is from a constitutional speedy trial demand is the interval from the arrest, indictment, or other formal accusation to trial. And we haven't gotten to trial, but we are going to trial on the 9th of January of 2023.
Here we are, June 22nd, and we still haven't started the trial. Yeah.
Considered to be presumptively prejudicial. So go ahead and start out with that. That's your roadmap.
Okay.
The state has responded. I'll let them go ahead and, of course, go ahead and make their argument. But go ahead and start off with the delay.
Would it be helpful to Your Honor, and I will follow your instructions, would it be helpful to provide a brief timeline of the key dates? Or is that clear to the court?
It's clear to me. I mean, to the extent that
we already
you
know
need
this.
to be able to show me.
Go forward to.
So I mean, I think that if you need to
witness,
establish
if
when
there
your
is
client was
one.
arrested, when he was indicted, any other relevant dates for the purposes of establishing what the court and my determination
there
of
is
delay, without delay.
No more
is,
witnesses
who that
on
delay
this
is
day, which
attributable
means we
to,
can move
because
on
that's, of course,
to day 3 of the Daubert hearing. Yay! It only took 5 episodes to reach day 3. Let me pick it up for you. Let's see here. Okay. It starts off with this for some reason. They are showing as you might see here, that it didn't start until this was shown. And I don't know why. Let's see here. There. We are in day 3 of the Daubert-hearing. And the Daubert-hearing was 7 days. 7 court days. That's the amount of experts they are trying to get in.
Okay, ladies and gentlemen, let me go ahead and first, again, good morning to everybody. Let's take roll and account for everybody. Mr. Adams, Khalif Adams.
Good morning, Judge.
Good morning, Matt.
Yeah.
Okay, good morning. All right,
Yeah, the judge has to make a roll call in the beginning of each day. Because at this time, there were over 20 defendants. With lawyers. Yeah, fun times.
Ante Bibi. All right, good morning, sir. All right, Damone Blaylock.
Good morning, Your Honor. Judge Hill, here on behalf.
Good morning, sir. All right, Jeffrey Williams. Good morning, Mr. Williams. Good morning, Mr. Adams.
Good morning, sir.
All right. Cordarius Dorsey.
Yeah. The buzzing sound is from
morning,
the court feed. It's not my fault.
All right, Christian Eppinger. Good morning, Mr. Johnson. All right. Mr. Menez and Mr. Farley, good morning, gentlemen. All right, Javon Fleetwood. Mr. Fleetwood, good morning again, sir. Demikian Garlington. See in the corner over there? Thank you. Good morning, sir. All right, Quantavious Greer. Okay, I think we've taken care of him already. That's right. All right. Okay, Marquevius Huey. Mr. Matthews, good morning. DeMonte Kendrick. Mr. Weinstein, good morning, sir. Denise McMullen. To the corner, thank you. Appreciate it. All right, Tenquarius Minder.
Good morning, Your Honor.
Good morning, Ms. Moore. Good morning, Ms. Fagan.
On behalf of Mr. Mendes.
All right. All right. All right, Ms. Bernard, good morning. Good morning, Mr. Myrick. All right. Cormarvius Nichols. Okay, good morning.
Yeah.
Yes,
roll
Mr.
call
Harvey is taking care of another legal matter that's in conflict. Are you going to just cover for him, sir?
Yes.
Okay, thank you very much. Mr. Nichols, you were explaining that, sir? Is that correct? Or Mr. Harvey is? All right. Okay, just want to make sure. All right, Rodeus Ryan, Ms. D. Williams.
Mr. Honor, Angela D. Williams.
Good morning again, madam. All right, and let's see what else we have. We have, all right. Mr. Sledge, is Antonio Sledge here this morning?
He is Judge Derek Wright.
Good morning, Mr. Wright. I hope you're feeling better, sir.
I am feeling 100%.
All right, wonderful, wonderful. Good to see you, sir. All right. Trontavious Stevens. All right, Mr. Stevens, your attorney told me of an issue she has as well. She should be here shortly, okay? All right, thank you. All right, Shannon Stillwell, Mr. Shart, Mr. Botts, good morning. Good morning, Mr. Stillwell. Okay, Mr. Hoover, good morning, sir.
Good morning, Your Honor.
I see him, sir. Thank you. All right. Okay, I think of a kind of a role for everybody now. Let me just kind of go through a couple of housekeeping things. As I understand it, Ms. Rosenwasser and team from the state, that you have your other witnesses lined up.
Let's move forward to the actual witnesses instead. Okay, Miss Love isn't here. This is another prosecutor, or is she around? Yeah, that's the defendants and the lawyers.
Mr. Wall, good morning, sir. If you'd be so kind to approach the witness stand, once you get there, turn and face Deputy Talton to be sworn as a witness, please.
He looks like a cop. Let's see what his name is.
I do.
My name is Daniel Worrell, Daniel Worrell.
Okay. Good morning.
Morning.
Investigator Worrell, where are you currently employed?
I'm an investigator at the Office of the District Attorney on the Blue Ridge Judicial Circuit.
And how long have you worked there?
Coming on 2 years.
And where were you working before that?
The Atlanta Police Department.
How long had you been there?
I began my employment in 2008.
Okay. And what are your duties at the, as an investigator at the Blue Ridge Circuit right now?
I'm assigned cases that vary from drug possession to murder. I prepare those cases for the attorney, collect evidence, interviews, things of that nature.
And what were your duties with the Atlanta Police Department at the time that you left?
I was an investigator assigned to the Criminal Intelligence Unit.
And, oh, sorry, go ahead. No, I didn't realize I cut you off.
There, we focused on violent crime, gangs. I had a particular expertise in digital evidence, phone records, and things like that.
Now, can you explain what you mean by digital evidence?
So CDRs are call detail records, phone records, social media, things of that nature, not physical evidence.
Do you ever do any work with that at your current job?
I do.
Okay. And did you ever do that at any other law enforcement positions?
No.
However, while I have you here, I will ask you, can you go through all your past law enforcement experience?
Yes. I was forsworn. I was employed by the Atlanta Police Department. Before the Atlanta Police Department, I worked for the Florida Department of Highway Safety and Motor Vehicles as a communications officer. That wasn't law enforcement, but it was connected to law enforcement. But then in 2008, I was hired by the Atlanta Police Department.
And do you have any relevant education, college, anything like that?
I have a bachelor's degree in criminology.
Okay. Have you attended training as a police officer, investigator, and throughout your career?
Yes.
Can you detail some of that training?
So I have close to 2,000 hours of post, which is the police officer standards training. Ranges from going through the academy, through high-risk warrant service, to digital evidence, undercover operations, list goes on and on.
Can you specifically explain if you've had any training on cell site location information or
God, cell towers.
No. It's more
shit evidence.
Closer to cell site location information, mobile forensics. I've dabbled in, but I'm
Can
not.
you, specifically as the cell site location information and digital forensics, can you explain the training you've had there?
Yes. I attended training with Hawk Analytics, I believe it was 2018, for cellular technology, mapping, and analysis of CDRs and cell site location information.
Oh, well, we have to go through it.
FBI's cellular analysis survey team for understanding investigations for modern telecommunications. I've attended training with the Secret Service at the National Computer.
Is the sound as loud for you as it is for me? Yeah, don't we all just love the cell phone experts? Yeah, cell phone, cell tower, yeah, amazing. Sound is fine, okay. let's go on.
Forensic Institute on Digital Evidence, where we had a module on civil forensics. Attended training with ZX, which is a private company that creates mapping technologies and things like that. That was also pertaining to cellular technologies, mapping analysis of cell site location information and CDRs. Had another training with Hawk Analytics for tower dump analysis, which a tower dump is requesting records from network carriers for specific locations that certain towers cover.
Okay. And is that all part of the continuing education that you do to keep up with your work at the DA's office and in other offices you've worked in? Do you do any other continuing education that I haven't asked you about?
I'm currently in the middle of a modular e-learning training on forensic analysis of networks. It's through ZX as well.
And what do you do to keep up with any developments in this field and make sure that you're up to date on the trainings?
So
I remember her from The Shining. She looks young.
Monitor the National Domestic Communications Assistance Center, which is provided by the FBI, which will give updates on digital evidence and things of that nature. I try to keep in contact with other experts in the field when it comes to cell site location information. So FBI agents who are attached to their cellular analysis survey team, things of that nature.
Your Honor, at this point, I would like to show the witness what's been pre-marked as I do not know what number we are on. Is it?
Let's find out, Ms. Reaver.
On 12.
Page 12.
What has been pre-marked as State's Exhibit 12. And I have it here if anyone would like to see it first.
Is that the CV?
It's the CV. It's been provided in discovery.
All right, you may approach, madam.
Thank you, Your Honor. Would, sir, do you recognize this document?
I do.
How do you recognize this document?
This is my CV.
Have there been any additions, substitutions, alterations, deletions as far as
I can tell, no.
Your Honor, the state would move to admit State's Exhibit 12 to evidence for the purpose of this hearing.
Any objection? All right, having hearing none, stage 12 is admitted.
Thank you, Your Honor. And Investigator Worrell.
Yeah, that's her. Isn't it? Yeah. Shelley Duvall got herself a new job.
You've detailed a little bit that you've done some of the cell site location information work in your current job and your previous job. Can you detail about how often you did this work both at the APD and now?
With APD, it became a daily thing. I was consulted a lot with or by other investigators who had phone records that they needed interpreting and analysis for. I would look at phone records every day. When I moved to the district attorney's office, it's, I would say, weekly that I look at phone records and consult with attorneys and investigators in regards to their evidence pertaining to that subject.
Have you ever given any kind of presentations, writings, anything like that that I haven't covered?
I've given a couple presentations, yes.
Can you detail those?
One was a training for our investigators at the district attorney's office, which focused on briefly on the technology, but as well as investigative techniques you can apply using CSLI and CDRs.
And does CSLI, is that cell site location information?
Correct.
Okay, keep going, I'm sorry.
Another was a presentation a year or two ago at a gang investigators meeting in regards to investigative techniques on applying phone records and things like that.
And so I think you said currently, do any investigators or detectives come to you to ask you about how to do this?
Yes.
And are you able to explain how this cell site location information works?
Yes.
Okay. How often, and I know this is going to be a hard question, about how many cases have you done, would you guess, ballpark cell site location information for? Ballpark is fine.
Over 100.
Okay. Have you ever testified as an expert witness in a case regarding cell site location information?
I have.
Okay. And how many times have you been qualified as an expert?
7 or 8.
And what courts were those in?
Here in Fulton County and Cherokee County.
Okay. And what specifically were you qualified as an expert in?
Yeah. If you go back and watch the video enhancement guy, that guy has been an expert for the state over 50 times. So in Georgia, being accepted as an expert doesn't really tell us much, does it? But we will see.
The analysis of call detail records with historical cell site location information. So it's kind of a mouthful, but the analysis of historical cell site location information.
And finally, do you have any awards, commendations, or anything else that we haven't mentioned? No. Okay. Can you explain how cell site location information is generated?
Yes. So when we enter into a contract with a network provider, let's say Verizon or AT&T, we're issued our device as well as our unique subscriber information. Now, cell site location information CDRs with cell site location information originated more as billing purposes. The providers needed to keep track of kind of what their clients, their activity was, only to really just maximize their product. They needed to know, if they were getting dropped calls, and as well as how they were going to bill their client. It used to be a time when we would be charged for going over our minutes and more texts and things like that. So that's kind of how these records were initially created. So anytime that we make a phone call, a text, utilize data, it is tracked by the network provider, has general information of date, time, who we're calling, and as well as which cell site or which tower enabled that cellular transaction, which enabled the connection to the network.
Okay. And so does this process generate information about locations when you do it correctly?
Yes. So depending on your carrier, they will provide in that particular record.
You know what? The best part in looking at these things afterwards, because I know you have been at Jeff's stream, most of you, and you have seen cell tower crap. Excuse me. So let's move on to the next witness.
Nature can be utilized for. So what's your specific?
There is no error rate. So at the point where he's supposed to give
there, because this will be again in the trial.
Okay, next.
Yeah.
Call your next witness.
Yes, Your Honor. State will call Mr. John Pulisic.
All right, Mr.
Hey, what now?
Pulisic. Summon Mr. Pulisic, please. Mr. Pulisic, hold on one second. You step outside just a second, please. Just 1 second. Give me a second.
There are also people attending via Zoom. So you saw earlier the photo and or the feed from the courtroom, and there's a lot of defendants, over 20 of them in this RICO trial.
All right, as it relates to Mr. Worrell, I just want to complete the court's analysis. I am under my gatekeeping function in or required by Daubert and 702. Going to find that he meets the threshold to testify as an expert in the aforementioned areas of CSLI and historical cell site data information. The basis for the court's ruling is his testimony on his training in digital evidence, digital forensics, the trainings that he's received by the various agencies, the length of time that he has that he has been in law enforcement. He has done well over 100 cell site investigations. He's been qualified as an expert 7 or 8 times in Fulton and Cherokee counties, and his methods are generally accepted. And
yeah.
it's also for the record.
Very small request, and I think you're on.
Without for you on the now commensurate with each habit with that notes have please stand. Once you get there, if you'd be so kind and turn and face Lieutenant Gibson, be sworn as a witness, please.
Raise your right hand, sir, remain standing. Do you swear or affirm that the testimony you give in this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may lower your hand. You may be seated, sir. Watch your step. For the record, please state your name, spell your first and last, for the court and your occupation. Speak to the mic.
First name is John, that's John. Pulisic, that's P as in Paul, Aulisick. I'm currently in private practice, serving as an examiner of question documents.
It's pronounce your last name one more time, sir.
Pulisic.
Pulisic?
Yes. Yes,
Okay.
Your Honor.
Thank you, sir. I appreciate it. All right.
Thank you. So Mr. Pulisic, I know you said your job, can you explain what the nature of your work is as an examiner of question documents?
These names are.
Yes, as examiner of question documents, I examine documents in order to determine the authenticity of documents. The examinations that I conduct mainly in private practice are concerning handwriting and hand printing. I also conduct authentication of documents with examinations of paper, ink, rubber stamps, staples, torn paper, anything that deals with the authenticity of a document will be the type of examinations that I will conduct.
Can you explain, when you say authenticity, what does that mean?
What?
For example, in the area of handwriting or hand printing, I will receive documents of unknown origin, or we refer to them as question documents.
1972?
And the question to me is whether or not a particular writer was involved. In the examination, I will examine that question document with samples also submitted that have been authenticated as coming from a particular individual. These samples, which are referred to as known samples, are basically of 2 types. One type of known document would be documents, normal course of business documents that have been authenticated as coming from a particular individual. The other type of known documents will be when an individual in person provides samples of his or her handwriting.
Okay. So I want to get into your job history and getting into this. How long, you said you're in private practice. How long have you been in private practice?
Approximately 6 years.
Long.
And what is your practice? Is it a?
I want to hear. I
Will
really want
reach
to hear.
either a elimination of an individual or a positive association of an individual writer, or without statistics into his or her.
Understanding, yes, Your Honor.
All right. Any objection to states 13, 14, or 15? All right.
I object to stage 14. It does not matter how many times this man has testified. He can testify a million times if he wants to. It has to be with how he's applying what he did in this case at this time. I object to 14 because it can be 1, it can be 100. That's not relevant to what we are arguing and what we're looking at today.
Any further objection? All right. States 13, 14, and 15 are admitted over objection.
I need to get myself. Yeah. Yeah. Yeah.
Mr. Pulisic, can you explain the method that you use to analyze these question documents, specifically if you're trying to compare a signature, determine who wrote something?
Yes, there are definite protocols and a methodology that's been established over the years. The examination, as I previously testified to, is comparing a document that is in question. In most cases, in my private practice, that deals with signatures. And the comparison is done with a side-by-side comparison. In other words, the question document is examined and compared to known samples that have come and have been
I thought this
authenticated as coming from
handwriting
a
expert
particular writer.
has been gone
The
for
side-by-side
years.
comparison is a protocol that is utilized by all
Yeah.
forensic document examiners. In my examinations, I examine, according to the protocol, I examine the known samples first before analyzing or examining the question. The examination of the known samples will be in order to determine the various characteristics that a writer in.
Yes, it's 8 p.m. here. So it's not daytime drinking. It's just drinking. Oh.
Inserts into his or her writing. The methodology is based upon the fact and the main principles of forensic document examination and handwriting is that no two people write the same way. And
No. Oh. Yes. No two people interpret tarot cards the same way. So that's why we can use it as a science. Jesus Christ.
individual does not write exactly the same way twice, that a individual will insert characteristics into his or her writing that repeat themselves, and that lastly, that a writer cannot go beyond the skill level of his or her writing.
So is this, I guess, can you explain what is there a certain method to
Information and the
have been written about it?
conclusions prepared the
practice. You work documents. Sir, got a few questions for you, please.
Yes, sir.
I noticed in looking at your CV and the other documents that were admitted, I believe it's States Exhibits 13, 14, and 15, if I'm correct, and by your testimony, that you currently are in private practice. You work privately with your own company, correct?
Yes, sir.
All right. You were last employed by the FBI in what year?
I reached mandatory retirement at the age of 57. It's a mandatory retirement for all agents. I retired in 2007. And after that, moved to Atlanta, where I worked in the Georgia Bureau of Investigation Laboratory.
For 2.5 years, is that right?
Correct.
And so if I'm doing my math correctly, you last worked with the GBI in 2009, 2010 at the latest?
Yes.
When was the last time that you were qualified as an expert in the field that you've been tendered in?
I'm not sure of the date, sir, but it would have been a deposition where I worked a civil case.
Okay.
It would be within the last 6 months.
Okay.
A civil case.
And that
Was
was,
it used?
you were qualified as an expert for purposes of a deposition?
Yes, sir.
When was the last time that you were qualified as an expert in a court, whether federal or state?
I wouldn't know the exact, sir, but it would definitely be within the last year, and it would have been in the state of Georgia.
Okay, thank you.
Courtroom.
Georgia is 15 to 20 years
State
behind
courts,
when it
either
comes to
Superior or State in
God, no.
Georgia.
Yes.
All right.
We are 2 hours in. This is.
I wanted to ask you some very specific
Jesus.
questions about, and just so just from a starting point, I think the last question, maybe the second to last question you were asked by the state was whether or not you were asked to review and analyze a particular document or documents in this case.
Yes, sir. Yes, sir. I received, excuse me, I received 2 submissions relating to the same subject.
Okay. The subject would have been Jeffrey Williams.
Correct.
All right. When did you receive those submissions?
If I could refer to my notes, Your Honor.
Please do.
You can.
With the court's permission.
You can, sir.
So he has one paper here with some form of handwriting. He knows beforehand that it is from the same person. Probably. Maybe he will say something else. And then he sits and looks at it and says, yes, it is. Or yes, it isn't. It's crap science. Because it's entirely based on opinion. Not facts. Opinion. It is, scientifically speaking, worthless. Completely worthless. Jesus Christ. I need more beer. Listen to this guy.
Okay, the first submission that I received was June 28 of 2022. And the second submission was received December 9th of 2022.
Okay. First submission in June of this year, second submission in December of this year, maybe about a week and a half ago or so. Does that sound about right?
Correct.
Right.
Yes.
Yep.
Again, as a starting point, you use the method.
If
the
I'm
methodology,
hungover,
that you referenced
if
earlier
I'm
in
stressed,
analyzing these documents
everything
that were
matters
submitted to
in
you.
handwriting.
Yes, sir.
Your ultimate conclusion to use your scale, I'm going to use that word, is that you made a determination that Jeffrey Williams, quote, probably prepared the documents that were submitted by you or to you, correct?
Yes, sir. That was part of the report dealing with the first submission that I received. The second submission that I received consisted of 3 documents that were originally provided in the first submission. So the second examination of the second submission, the results were the same as the first because the documents were obtained by me with the first submission.
Okay. Now, in regards to the documents that were submitted and your methodology, am I correct that you indicated in the testing of these documents that your ability to make any sort of definite determination was limited? Is that true?
Yes, I reached a lesser than a full identification of the individual writer.
Okay.
Less than full is 0 to 99.99. That's shit. Jesus Christ.
Okay. And so I want to ask you about what you've referred to. We talked about error rate a little earlier, right? So I want to ask you about the error rate and the potential error rate specifically in the examination of these documents that are at issue here, okay? Did I hear you correctly to say that when you worked with the FBI, your work was routinely peer reviewed?
I'm sure your handwriting is more just tweeting.
Did I hear you to say that every case was peer reviewed?
Correct.
All right. And
Bullshit. Bullshit. There's no way to peer review non-science. Bullshit.
the importance of peer review is what exactly?
It is to ensure that the results in my report are accurate and were reported according to FBI protocol.
Okay.
And the examination, if in question, would be peer reviewed by not only my unit chief, but also another qualified document examiner within the lab.
Okay. And again, the importance of that peer review is to make sure that protocols that you've referenced previously and that are utilized, that are part of best practices, are followed. True?
Yes, the peer reviewer would utilize the same protocols and the methodology that I used and were taught to me during my 2-year training period.
In the examination of the documents that are at issue here, that was submitted to you first in June of this year and then again in December of this year, were your results peer reviewed?
No, sir.
Okay. So no one peer reviewed the results that are at issue in this, that we're testifying about here today, correct?
While in my private practice, I will ask for peer review if in fact I have some level of uncertainty as to my results prior to my putting the results in a formal report.
Okay. Am I correct that in the document that you've provided, that is the again, I'm going to use the term sliding scale, your degree of certainty as controlled by the protocols that you've discussed previously go from where someone definitely, or a document is definitely prepared by the same person, correct?
Correct.
All the way down to definitely not prepared by the same person.
Correct.
Right. In between those two extremes, those two certainties, probably are prepared by the same person. Under that is may have been prepared by the same person. Under that is no conclusion could be reached as to whether they are prepared by the same person. Under that is may not have been prepared by the same person. And then probably are not prepared by the same person. And then, of course, the last one.
In my opinion, it's either he can state his opinion. Yes, it's my opinion. This is that person. Anything other than that, then it's not. That sliding scale, it's bullshit within bullshit. Peer review peer review in his sense of the word is my paper on the flatness of planet is reviewed by my fellow believers in lack of a sphere. Exactly. So, but peer review is someone independently of your research can look at it and see if it's valid independently. That doesn't happen within this scam science.
Definitely not prepared by the same person, right?
Correct.
All right. So I want to ask you a question then about what we discussed earlier about error rate. You testified to the court that in studies that have been done,
it can depend on the 2-hour mark as well.
Individual to a trained individual.
Then I can actually
the error rate for the non-trained individual in the examination of question documents would be about 60%. True?
During that study, that particular study, yes, sir.
The error rate for a trained document examiner with specialized knowledge was less than 1%, correct?
Correct.
Now, is there a difference in the error rate? If we're looking at, for example, you reach a determination, and this is hypothetical, you reach a determination that a document is definitely prepared by the same person. There presumably would be an error rate in that analysis, correct?
Yes, there would.
All right. Would the same error rate apply when you come to a determination that a document is probably prepared by the same person? Or is there a higher error rate?
Mr. Adams, I won't interrupt you. I hate to do this, but this is weight sufficiency cross-examination at trial.
Well, it goes to the witness's ability to testify about error rate, and specifically because the error rate or the determination made here.
Handwriting experts should not be allowed
in terms of
court
question document
anywhere.
examiners. This is the language they use. You can ask them that language and its meaning at trial, but it doesn't.
But then it's too late.
Validate his,
If the jury
the
hears
science
it
behind
and they
this,
have notion
or
of
an issue, or go
this
to your question doesn't go to my
science
gatekeeping
is correct.
function. Put it that way.
Then
the
it's
science
to weight more than
what,
sufficiency.
The science behind it is
then it's more what's the word? It's not pro-valid. What's the word I'm looking for? Chat, please help me. What's the word I'm looking for here? It's more blah 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 than probative. Whatever. It's shit science.
one thing, but as been stated previously, whether or not the methodology was properly used and whether or not there is an error rate, because that is one of the things that Daubert in 702 says that the court has to consider. What is the error rate? And that's exactly what I'm asking.
Thank you, Michael. It's more prejudicial than probative.
It's not specifically say I have
It's
to.
shit
I have
science.
to use the error rate.
Only purpose is
that the Daubert I'm required to look at 4 things, and also depends on what.
Ladies and gentlemen, we have a guest. The man, the myth, the frosted tips. Hi, Larry.
Hello, Nicholas. How are you, my friend?
I'm doing. It's interesting. We are currently watching a handwriting expert, and you are drinking French coffee. How is it in Paris, my friend?
Very busy. Apparently, I'm in some area that is quite hustling and bustling, even though somebody told me it's like going to New York City and staying in Harlem.
Yeah, I can see that.
I think it's called. I'm gonna butcher the pronunciation, but I think it's Montmartre.
Montmartre.
It's like north of the Louvre.
Yeah, Montmartre. Okay. Yeah.
Yeah. What are you guys watching?
We are watching the Daubert-hearing in preparation for the RICO trial of Young Thug, the rapper, and it's a RICO trial. And
Yes, I remember hearing about that. One of my associates at one of the meetings about 6 months ago pointed out that they were being indicted.
Yeah, and it's still in the preparations. The trial should have started January 6th, and it's still not past jury selection.
Wow.
Yeah.
Why is that? Like, what's the cause for the delay?
It's we are past 2 hours now. It is a complete clusterfuck. Complete. Within these Daubert hearings, we have not reached that point yet. That has there has been accusations of drug handling in the courtroom, possession of prescription drugs without permission from the court. 2 or 3 lawyers have been in contempt of court, and 2 of them would have to write 20-page essays on how to handle themselves in court, and 1 had to buy lunch for their colleagues. Then in jury selection, 1 juror was sent to jail because she filmed in the courtroom.
What the hell is going on here?
Exactly. What the actual F? 4 or 5 of the original 28 defendants in this RICO trial still, over a year later, has no lawyer.
Wow. Yeah, I haven't been following this trial as closely as I would have liked. So this is all news to me.
Yeah, it is amazing. And oh, you have people. Yeah.
I did not see the Johnny show yet. No. That's on the 25th and the 27th. The 25th in Paris and the 27th in Hamburg, Germany. I bought my flight, but I still need a hotel in Hamburg. Unless anybody has a crash pad, I'm happy to stay with you. I'm just kidding.
Well, if any, there's Danish people and Swedish people. I don't know if there is any German people or French people in. It's probably not any French people in the chat.
Right.
That's the area that gives Gay Paris its name. Okay, Montmartre. Yeah. There's a movie 20 years ago, Amélie from Montmartre, that was Oscar nominated. But it's a
Mont means mountain.
Yeah.
But I don't know what Marthe means. Death mountain? No, that's mort. I don't know.
Let's see here. The English translation of.
I know Mont Blanc means White Mountain, and it's a brand. I now know 3 French words.
I trying to find some translation here. Torture.
What?
Mort. Dictionary from Germans from Martin.
Did you say torture?
Yeah.
Mountain of I live in the mountain of torture. Leave it to me, the BDSM guy, to fucking live in the mountain of fucking torture. Are you joking? Are you joking? This is like a last minute book, but fuck, I'll take it. Whatever.
Yeah. No. Let's see here. Here. From German Martin, to torment, derived from martyr, torture, borrowed from late Latin martyrdom.
No wonder it's the goddamn ghetto. I am living in Harlem. But dude, the crash pad is like tiny. It is so tiny. I can't even describe in like square feet. I have it's like 7 square feet, man.
Jesus Christ.
And there's no air conditioning. I just have like an AC fan or whatever. And I mean, it is quite busy though. Like I ventured off the beaten path a little bit, so you can't see it. Like my unit is over there, and I just kind of started walking, and of course, leave it to the fucking American to find the only Starbucks within a 1 mile radius. So I found a McDonald's. I found There's the McDonald's right behind me. I don't know if you probably can't see it. If I stop blocking it for a second. I don't know. It's right behind me over there. Okay. The McDonald's. So I have a Mickey D's and I have a Starbucks. I'm a happy American. You know what I'm saying? So it's like a jail cell. It is basically like a jail cell with no bed, and there's this pillow and there's like these weird bugs on it. So I had to I want to incinerate that fucking pillow, dude.
Yeah.
It's so like this is I am like I said, it was the only place available to book it within I had less than 24 hours prior to my arrival when I started booking everything, and I was I needed a place for 10 days. It's where Sacré Coeur is located. What is that?
Sacré-Cœur. It's
Sacré-Cœur.
Let's see here.
Sacred something?
Sacré. It is the Basilica of the Sacred Heart of Paris. So it's a church of sorts.
I'm not far from the Latin Quarter, as far as I know. So, well, I say not far. It may still be a hike, but my mom is going to be in Paris next week.
Oh, nice.
So when she told me she's going to be here, I'm like, I've never been, so might as well. Let's call it a vacation. Or a workcation if the tax man asks, of course. I am going to be working.
So it is around here. Funiculaire de Montmartre. Then you have, yeah, let's see here. So it is, it's there.
I don't care. I'm still happy, man. I'm still
Yeah.
excited.
Yeah.
It's actually,
You-
wait a minute. I just posted a photo. Those of you who have me on Twitter, I just posted a photo and there was like this, I crossed the street and there was like this basilica peeking from the other side, on the other side of the street, far away. And I took a photo with it in the background. I may have actually taken a photo with that on accident just now, literally like 10 minutes ago.
Yeah.
But I could be
Nice.
wrong.
Yeah. Now, I don't know if you've seen it, but currently we were watching a handwriting expert.
Yes.
And I didn't know they still were allowed in court. But you're a US lawyer, so you know this better than I do. Do they actually still use handwriting experts in court in the United States?
I mean, they can use whatever they want. There's no law in America or case law from the Supreme Court or other courts of appeals that I'm familiar with that discards handwriting experts. Now, that doesn't mean it doesn't exist, just because I haven't really had a whole lot of confrontation with the issue or needed an expert of my own on the issue, so we never got a chance to explore it. But if there is a handwriting expert testifying, then I imagine there's probably sufficient case law to allow them to do so, or the defense team was not able to find something to remove them. But I mean, a handwriting expert, I would always argue credibility. I mean, that's like the easiest avenue of attack, because to say that this handwriting that I'm looking at right here is the same, like, well, where we really needed a handwriting expert was the Johnny Depp trial, with all that writing on the mirror. When remember, I'll never forget it, because you don't need a fucking handwriting expert for this. If you remember, when Amber had that photo of herself when she was like topless and saying something to Johnny, like calling him Tonto, like basically, you're Tonto, you're mine, and forever, whatever, blah blah blah. When she went manic, so when she goes manic and she starts writing with this really jagged like handwriting style, that same handwriting style was on the mirror. And they all said that Johnny was the one who wrote it, but she wrote it. It was clear because it's the same like jagged, like the only reason I can tell is because when she had her psychomania phase, that's how you could tell. When she goes over the edge into that realm, it seems like the way that she was writing, the style, the mannerisms are extremely vivid, and like you can't mistake that for anything. So that's an easy example. But like when you're just trying to decipher someone's handwriting, and whether or not this is the same person who wrote this, I mean, the shape of the T, the crossing of the letters, all of that comes into effect. But there's a lot of room for error and credibility issues.
Yeah, and we are currently watching the cross-examination of this handwriting expert. So, I have share screen. I accidentally, and he looks like a handwriting expert.
Yeah. Well, listen, I'm gonna let you guys get back into it. I'm gonna continue exploring. I didn't want to leave you hanging. You've been inviting me for so long. I just wanted to pop in.
You're welcome back on Saturday on my midsummer stream, where we celebrate life, love, the summer. So one of the oldest celebrations we know of in history. So,
I love it. I love everything about that.
Yeah. So welcome back on Saturday. Everybody here already subscribes to Larry, the DUI guy.
Don't forget to like his video too.
Yeah. Subscribe to this guy. And thank you so much for stopping by. I love you, man.
Love you, man. I'll see you Saturday.
See you Saturday. Have fun.
Cheers.
Cheers. Oh, that was amazing. I've been trying to get a hold of Larry for so long to get him on one of my streams because he's always fun to have around. And he will be back on Saturday. He is in Paris, so he is in my time zone. The Swedish time zone and the French time zone is the same time zone. So he will be back on Saturday. And yeah, that was cool. Yeah. So let's get back to the clusterfuck that is a handwriting expert.
What type of examination, or what type of science that you're asking me to look at or consider in my gatekeeping function. But I got to consider whether the expert is qualified to testify competently regarding the matters that he intends to address, the methodology by which he reaches his conclusions are scientifically reliable. The three, the testimony assists the trier of fact, to understand the evidence, determine the fact and issue. Proponents may establish an expert's qualification in many ways, including scientific training, education, experience in a particular field. But there's no mechanical checklist for measuring whether an expert is qualified to offer an opinion in a particular field. When necessity, reliability, and methodology expert employs, the court considers the methodology, testability, error rate, Mr. and peer review and publication, general acceptance. I'm not bound by that, but I look at those factors.
Yes, sir. And that's my point exactly, Judge. Daubert does in fact say, in citing to United States versus Smith, 869 F. 2nd 348, 1989 case, Daubert does in fact instruct the court that, quote, additionally, in the case of a particular scientific technique, the court ordinarily should consider the known or potential rate of error. I'm not suggesting that
There is one for the particular field.
Yes, sir.
Okay,
and that is what the witness has testified to, and he's testified under direct about error rate. And so my inquiry goes to whether or not there is a difference in expected or anticipated or known error rate when a particular conclusion is reached, as in this case, where the determination is probably prepared by the same person as opposed to definitely.
Okay, but that's different. That's QD, and that's question document examiner language. That does not, I disagree with you, sir. The court has from question document examiners, and Mr. Paulsik has told you that these particular types of terms are terms that he uses in his professional trade that go along with him being able to reach a conclusion, which you can test. So, it'll go to weight versus sufficiency. Now, Mr. Paulsik, are these maybe I'll just clarify that before I let you answer a question, asking any questions. Mr. Paulsik, are the explanations you gave us to the types of conclusions that you give, are they standardized in the industry or the scientific field of handwriting or question document?
It's not a scientific field.
Okay, all right.
It's an opinion field.
So he's testifying about what QD question document examiners utilize in terms of their particular trade of responses. So those are acceptable. You're going to have to ask him at trial about those, or you can kind of wrap it up in terms of this, but that's what he's testifying about.
Thanks, Judge. And if the court's position is that I cannot ask that specific question that I was going to ask about.
Well, go ahead. But I'm telling you right now, I'm trying to get it why you're asking that question, okay? Well, and I want you to, I want to make sure, because neither one of you brought out that is the language of a question document examiner. They utilize this, and I just want to make sure I didn't put words in his mouth or say something that hasn't been kind of brought out before. But that question document examiners, when they testify, this is the language they'll give you, and it has a certain meaning. If you want to, so if you can continue at this point.
Yeah, and I'll ask just so I can. I think the answer to that question would give the court additional factors to consider in regards to the methodology. And so, Mr. Polisek, do you remember where we were in terms of what I was asking you? I was asking about error rate. And in this particular case, your determination was that this document was probably prepared by Jeffrey Williams, right? And my question then is there a different analysis for error rate when you reach that conclusion versus when you reach a more certified conclusion of definitely prepared by the same person? You understand the question?
Partially.
Okay.
The error rate does not pertain to the terminology that I utilize in my results of an examination. In addition, while I worked in the FBI laboratory, we were extremely conservative in our conclusions. In other words, in my degree of certitude is defined by my terms, and those terms have been codified by the agencies which I previously testified to, the FBI laboratory, ASTM, and SWIGDOT. These terms are utilized and codified in written publications by not only those agencies, but also by other forensic laboratories.
In regards to this particular analysis, you've testified previously that these results, both the ones from June of this year and the one from December of this year, were not peer-reviewed. Is that correct? I think you've testified to that previously. Is that right?
Correct.
Can you explain to the court why they were not? If the
rest of the handwriting
is
experts
accuracy, why were they not peer-reviewed, given your previous testimony
I don't
about
know.
the necessity or the importance of peer review, certainly while you were at FBI?
Well, my conclusions, specifically in this matter, were certain in my mind as far as an examiner.
They were certain in my mind. Jesus Christ, you're 102 years old.
Of 30 years. I would have, if I was not able to reach a conclusion, I would have utilized the middle term of my continuum, as I cannot determine one way or the other whether or not an individual writer prepared a question document.
When was the last time that any of your work was peer-reviewed?
It would be within the last year, but I'm not certain as to a date. What I routinely do is,
reviewed by who?
I am uncertain as to my findings, I will ask my partner to review the evidence that I've received.
Your partner, who is economically depending on getting work, who maybe you trained, and you go to him, her, whatever, and say, was I correct? Yeah. Jesus Christ.
And I will provide my partner with the submitted documents without giving what results I've reached in that matter. The peer review would be strictly done by my partner.
That's not peer review.
Right. But that was not done here.
That has to be independent of
in
you.
regards to the accuracy of your conclusions, is it true that you indicated that your initial analysis was done based on photocopies of documents?
Correct.
Was your second analysis, the one done in December, were those done from original documents?
No, sir.
Okay. So they're both done from those.
Oh God, no original document. So not even looking at the ink itself, not even look at the depth of the pressure, whatever the freak they are doing. He did it from a copy. Jesus. Oh.
Analyses were both done from documents with photocopies of signatures or writings. Is that right? Correct. And if I heard you correctly, the accuracy or your ability to make a definite determination is going to be limited based on analysis of photocopied documents.
That's correct. A photocopied or machine generated document is a two-dimensional document, whereas a original
Please become
document is a
members. Make
three-dimensional
this worthwhile.
document, which lends itself to additional exams such as writing pressure involved, the writing ink that may be involved. So the limitation, excuse me, the limitation.
Don't get me wrong, I am somewhat enjoying this because, in contrary to my normal work, where I'm negotiations, mitigations, analysis, I don't get to be emotional. So I'm enjoying this really, really much. But still, for fuck's sake. And become a member, please. It helps me.
The machine copies or photocopies somewhat
That's
limits
not what it means.
the possibility of
dear.
a positive association. However, I have associated machine copies or photocopies in previous cases and either definitely identified or associated with a writer or eliminated a writer. It is possible.
All right. Thanks, sir. Those are all the questions I have.
All right, anybody else?
I have a couple questions, Your Honor. Shart Hoover for Antonio Sumlin. Since you've been in private practice, how many sufficiency tests have you taken?
While in private practice?
Yes.
None.
Okay. So
No sufficiency
there are
test
no mandatory
for
peer reviews
16 years.
now that you're no longer with the feds, now that you're in private practice, and you don't take any more proficiency tests.
Correct.
Correct?
Correct.
All right. So this methodology that you're using, it's subjective, correct?
No, it's codified and all.
Bullshit. Bullshit. It is completely subjective.
Forensic document examiners follow the same protocols and methodology.
Well, let me put it like this. You as an examiner can notice something that gets you to a resolution, right? That's what you do. You notice certain things in handwriting that gets you to the conclusion of this person wrote it, this person didn't write it, or in between, correct?
Correct.
Another examiner, not your partner, not in your office, just another examiner, can get to the same conclusion, but noting different things in the handwriting. Is that correct?
I wouldn't be able to determine whether or not they were not utilizing the same samples that I did. And a qualified examiner would receive the same
Qualified by
documents that I
who?
received.
Other people?
And would observe
Who
the
look at
same
handwriting?
characteristics that are utilized by qualified examiners.
Sure. But you don't know if the other examiner noted every single thing that you did to get to the conclusion.
Mr. Hoover, that's kind of misleading because he's testified if he doesn't feel comfortable with it, then he submits it to another examiner. You're asking the
I
other
like this
question,
judge,
the
but-
converse of that.
Well, then let me rephrase. I apologize.
Okay, all right.
If you only peer review it when you don't feel comfortable and you don't take proficiency tests and you're basing it off of what you believe is true, how do you ever know you're wrong?
Good question.
Well, I'd be unable to determine if I was in error. It's still my expert opinion. And the opinion in most courtroom situations, I would prepare a demonstrative chart outlining characteristics that I observed or did not observe, so that the jury or the judge would be able to look at that chart, demonstrative chart, and observe the same characteristics which I did during my examination.
So in that long answer, I believe you just said that you don't know if you're wrong. That's what, you don't know if you erred or not.
No, I would have no way of knowing if I was wrong.
No further questions, Your Honor.
He doesn't know if he's wrong or not. Jesus Christ. I'm sorry, Steve Gosney, for taking the Lord's name in vain. I will use other word. For fuck's sake.
Anybody else? Okay, all right. Any argument?
Yes. Yes. I'm going to ask the court not to qualify this witness as a certified document examiner or whatever was proffered by the state. I understand Daubert, I understand 702. As my esteemed co-defendant's counsel has stated previously.
Esteemed. That's shade.
Methodology is important, protocols are important, but the application of that methodology in this particular instance is what the court should consider in regards to whether or not this person is qualified as an expert. And what I got to keep harping on is we start from a standpoint that this was not a certified resolution. He did not come to a conclusion that this was definitely this person. And so given that we start with some degree of uncertainty, saying probably is an uncertainty, given that we start there, the question that we...
Let me hijack you. I'm going to hijack you. Probably is a question document examiner's term that you can cross-examine him on when it goes to...
By then it's too late.
All question document examiners utilize the same language.
The language, the word probably...
Okay, we're going to just disagree on that one, okay?
And that's fine, Judge.
Mr. Adams,
that is...
Given his field and trade, that is what he's testified to. It does not have the meaning that you comport it to. So, unless you've got some other methodology, I'm waiting to hear it.
Let me continue with my argument then. Yes, I would start. My argument was that given that we start from a determination that using the word probably, the court has to take a look at whether or not the Daubert standards are met. And what Mr. Hoover said was that exactly the question goes to the point. He is unable to determine if he is wrong. This is an analysis that was not peer reviewed. And the witness started by talking about the importance.
Yeah, but he told you why it wasn't peer reviewed. That goes to weight.
Well, no, he did not explain why it was not peer reviewed.
Yes, he did. I'll tell you the answer right now. He said it's not peer reviewed because he's comfortable with the analysis that he made.
Right, and he's comfortable with the analysis that he made, but he does not.
Given his 30 years, and then...
If it's... every scientific, real science is always peer reviewed, because that's the way science works. It has to be questioned and questioned and questioned again. And if it survives all that questioning by independent in a same field or related field. But if the general consensus in actual science says this is not an actual science, then it cannot ever be peer reviewed. I hope this kind of shit science will be abandoned. The only way this should be allowed is when they say we could exclude. That's the only way. Not maybe, not probable, not I have a hunch. Don't give a flaming fuck about that. Because it's subjective in its core. It's not a science. Yes, actual boomer, preferably reviewed by someone hostile to your conclusion. Probably means probably not. Exactly.
Then he said if he wasn't comfortable, he would get another examiner to go, usually his partner, to go ahead and do that. He didn't feel he needed to do that in this case.
But that's the Dunning-Kruger effect in its core. If someone is very confident in saying, yes, the earth is flat, or something moronic like that, does that mean he's an expert that presents science? No.
So when he was with the FBI, he had the mechanism doing that.
Subjective to belief as to whether or not they are accurate or not is not, and then deciding, well, I'm not going to have it peer reviewed because I think it's fine, is not a scientific method. A subjective belief is not a scientific method or the use of scientific methodology. I would simply, and the witness explained in detail about his time at the FBI, his 20 plus years, his time at the GBI, and the importance of peer review and why that was important. But in this case, in this particular case where determination is made, it was not peer reviewed. And that is certainly something that the court ought to consider as to whether or not he ought to be qualified. Not just whether or not this science is acceptable. Yes, the science is, or the methodology is acceptable. It's been acceptable in courts previously, but as applied in this particular case, are the factors that Daubert and 702 require applied in this case such that he should be qualified as an expert? Well, I simply would contend that he's not met those standards. That is an extremely important portion of whether or not the science should be acceptable and whether he should be qualified as an expert. I would contend that he should not be.
Okay. Thank you, sir. Mr. Hoover.
Yes, Your Honor.
As soon as I got you next, okay? All right.
Sean Hoover again for Antonio Sumlin. And Your Honor, I have to make this clear.
Mr. Hoover? Without address? Okay. People think Bill Nye is a scientist. He's a mechanical engineer. He's an excellent presenter of facts or science. But, as Captain Halfon says, he's not a scientist in itself. Okay, yeah.
Regardless if we're talking about 702, regardless if we're talking about Daubert, regardless if we're talking about Kumho-Tyer, it all comes down to two things: reliability in the methodology and reliability as the way this person applied it. As the gatekeeper, you have to determine that what goes to a jury is reliable. I have to disagree with what you said because the witness literally just said, I'm right because I think I'm right, but I don't know if I'm ever wrong.
That's part of the examination for you. I mean, he's testified that's the methodology, and that in terms of how he and why he is not peer reviewed this particular issue. So I mean,
but Your Honor, the reason we go through these hearings is because the state is trying to qualify this person as an expert, which puts him above a layperson, which puts him above an officer.
I understand.
The expert is supposed to be able to apply information or give information to a jury for them to understand something they can't understand. So at the point where the witness says, I don't know when I'm wrong, how does he tell it or give information to a jury for them to understand anything else?
If he's wrong, which he says is not able to make a determination or a conclusion, then of course he would then at that point in time have it peer reviewed. But he's comfortable with his particular analysis, so that's why that's the explanation, and that's utilized in his field or trade of occupation.
And I think you are missing the reliability part of this. The point is, he doesn't get to go to open that door and walk through as an expert until we know that the way he did something is reliable. Simply because he says he knows it's done.
Okay, remember. This is the science of fingerprinting, or I should say, of question document examination.
True.
Expert threshold. All those things you're mentioning
not a science.
Go to when he comes to trial and he presents the standards. When he presents against a known versus question document, all the things that you're saying are perfectly clear and can be examined.
True.
Don't disagree with it at this point in time, okay?
Yes. The problem is that's not 100% true. The court has to look at reliability of the methodology and reliability of the person that is applying the methodology in this case.
Testability, error rate, peer review, and publication, and general acceptance. Those are the factors that I look at. Okay, so they're factors. Okay, there's not a hard and fast rule. I know that you keep harping on this, and I understand that you're doing your job, but I'm just telling you at this point in time, it certainly goes to my gatekeeping function, but it certainly as well goes to your ability to examine this particular witness. Should he be called to testify at trial?
And just to make the record clear, I object to this person being qualified as an expert under the validity as applied reliability standard that the court must consider before he becomes an expert.
I'm saying I have, and I'm telling you, I have applied that. Okay, so Mr. Jimmons, go ahead.
Good morning, Sudi Chada Jimenez, on behalf of Mr. Dorsey. And just want to lay out my argument, and I don't mean to be repetitive. I'm just trying to keep my thoughts together. It is hard. I'm trying to.
Okay. Well, maybe you can bring up something new that hasn't been otherwise articulated by Mr. Adams and Mr. Hoover.
Absolutely. Yeah.
Okay.
Yeah. I just want to make it. We all know that the new rules of evidence that have been applied, we've adopted in Georgia a few years ago, federal rules of evidence. They tend to lean towards admissibility. It is something
Well, the federal rules as a whole do.
Yes,
Yeah.
and in Georgia, we want the jurors to see the evidence, to hear the evidence. We want them to, if something goes to prove that a fact is more likely or less likely, then it's relevant, and we want them to hear about it and make a decision. I do want to make a distinction, Daubert and Kumo. It kind of goes the other way. That's what gatekeeper is. Gatekeepers are these young men with weapons and vests and tactical gear. They're keeping the gate from making sure that we don't get rushed by a bunch of public and silly people that are going to make phone calls and do stupid stuff on Zoom. They're the gatekeepers because we don't want to know that because that's irrelevant. That has nothing to do with this case. And that is your role, Your Honor. Respectfully, that is your role to make sure that some of this stuff doesn't just come in because the state wants it and bolsters it. Experts have a different standard. An expert can testify as to hearsay and stuff that they haven't seen or done themselves. They can give an opinion. Why? Because they're experts and they have the experience. There is no doubt that this man is, Mr. Polsnick, I apologize, sir, is an expert. He has had the training. He has had the experience. He has had peer review. Most importantly, and the state went really into detail with this. And you know why? Because it matters. He knows the methodology. We're not talking about hard science. We're not talking about chemistry and physics. We're talking about handwriting. But you know what? I can't tell. If you show me like some scribble, I don't know if it's Mr. Williams' signature. It might be former President Trump's signature. You know, just a bunch of squiggly lines. We need somebody like him to tell us. But here is the key. Again, Your Honor, I'm referencing mostly Kumo Tire versus Carmichael. That's 526 U.S. 137, 1999 case, Supreme Court. What it said is pretty much, you know what? The Daubert standard, you can't just apply it to hard science. You're going to apply it to anything else that requires a certain level of expertise that a lay person cannot understand, because that's the key. Can you please explain to everybody else what it is that you have studied so hard for? But you have to do it right. It's like a recipe. It's like making a cake. I ain't no expert. I am not a chef. And you can give me all the ingredients. You can give me a bunch of flour and eggs and whatever. You give it to me, I don't know what to do with it. You know what I have to do? I have to follow a recipe. There is a methodology, step by step. And he has testified that there is a methodology that exists. And when he was under the supervision of the FBI, the federal government, somebody with standards and somebody wants to make sure things are done right, he followed it. Part of that was peer review. So, you know, I just want to say that. Yes, Kumo says that scientific knowledge is not the only thing that we're going to apply to the Daubert standard. We're also going to apply it to technical and other specialized knowledge like this. It is flexible. Let's remember that Kumo was not about letting everything in. Kumo was actually about a case about the expert that the plaintiffs wanted to put up and say that he knew why the tire exploded, because either this happened, and if that didn't happen, there's a manufacturer error. And you know what? The defendants were able to get that suppressed because he didn't apply the science correctly. He didn't do what he said can be done. And then, you know, they went up to the Court of Appeals and Supreme Court. They're saying, No. You can't use the Daubert standard on him because he's not a scientist. Supreme Court just said yes, and the discretion for the court not to let it in. Not discretion for let's just let everything in and let a jury determine as to weight and admissibility. No, we want the jury to not waste its time with all these fancy titles.
But you'd agree that handwriting has been around 100 years.
Absolutely.
So is there any, I mean, how would you address that? I mean,
handwriting has been around 100 years.
And question document examination of handwriting.
Oh, the tool marking with
And it
the
was
shit
not
science.
the methodology that
So
he
has
knows was not
lie
applied
detector.
in this case.
And lie
And a lot of the
detectors
other
are
experts,
no
I'm just
longer
gonna make my argument
admitted.
now because I don't want to have
But
to
it's
keep standing
shit
up with the
science.
same exact point. You
No,
have
no,
to
well,
apply.
do
Because
so.
it's been around for a
You
long
have to
time
apply
doesn't
the
make it a
methodology
science.
that you claim it is. Some things don't have a methodology. Some things you just know how to do and you use certain tools or you have the education, but they're just not a recipe. But in this case, he testified there is, and he testified he chose not to use it. Because one of those things, as he had said, why, Mr. Adams asked, why peer review? To ensure results are accurate and done per protocol. Protocol, what is protocol? You have to follow the steps, you have to follow the recipe. Why do we have protocols? Why do we get up and accuse police officers of violating people's civil rights because they didn't follow the standard operating procedures? The protocols, follow your protocols, follow your own rules, follow the rules of the science that you should be respecting, that you know they exist for a reason. They're not just there to CYA. No, they exist there because you want to make sure it's done right, whether it's for the government or for the defense or for some tire company. You want to make sure it's done right. So, Your Honor, and I'm sorry, again, I'm trying to keep up with my notes, but no desk makes it a little difficult. So,
Do the best you can.
my apologies.
All right.
I just want to emphasize, Daubert, it establishes a standard of evidence reliability, which requires a valid connection to the pertinent inquiry as a precondition to admissibility. We are trying to determine not whether or not the science exists, not whether or not he's an expert at the science, but did he follow the steps properly as a precondition to letting a jury hear from him as an expert. That's my entire point, Your Honor. You can do whatever you can talk about any sciences you want. You can bring in all the experts you want, but just make sure they do it right before we do all of this dance in front of a jury that's just going to be confused if you didn't do it right. Yes, it goes to weight and admissibility, but it also goes to the gatekeeping. Don't let the jury hear stuff that was done improperly. Let them hear the good science. Let them hear about the proper experts that follow their methods. Don't let them just hear about anybody just because they're an expert. It's not a question as to is he an expert? It's a question about if he applied his expertise properly to this case.
Good point. Good point.
My last point, Your Honor, I think it's not part of the order, but late Justice Scalia, which always his dissents are always very on point. I think it is worth adding, it is not discretion to perform the function of whether it's inadequately. I'm sorry, I apologize. I think it is worth adding that it is not discretion to perform the function inadequately. Rather, it is the discretion to choose among reasonable means of excluding expertise that is false and science that is junky. But if there is a science, let's use it. If there is a recipe, follow the recipe. Don't just throw everything in the blender and then toss it in the oven and hoping that you're gonna get a 3-layer cake with beautiful and tasty results, because that just doesn't happen. You have to follow the steps, Your Honor. Thank you.
All right.
Good
Ms.
point.
Rosenwasser?
Nobody else?
I think you're good.
I mean, I've got more.
You kind of
Let's hear
inadequate
from
now.
Shelley
He
Duvall.
made a cake analogy, right? Yeah, you feel bad about that, don't you? Okay, all right, okay. Go ahead, Matt.
Well, Your Honor, I don't know much about cooking, but I do know that the law supports the admission of this expert. That's what I do know. Your Honor, so first of all, I want to start. I think the defense may have gone a little astray. The peer review factor goes to whether the science itself is peer reviewed, not whether he has had his item peer reviewed. If Daubert required every expert to have whatever they did peer reviewed, that would mean that by law, every case would require to have two experts to have anything admitted, and that is certainly not the state of the law. Whatever.
If that's not the state of the law is wrong. Irreparably wrong. And it can be done via anything. A scribble on a paper. I peer review this. I use this method to peer review. It's being admitted. It takes less than 5 minutes.
It has to do with cakes or not. And Your Honor, the law is very clear that his science has been accepted in the 11th Circuit. Your Honor, the leading case on this out of the 11th Circuit that I found is called United States versus Paul, Paul.
Yeah.
That's 175 F3D 906. That's a 1999 case of the 11th Circuit. And I want to point out that it's been upheld several times, but I like to point to that one as the leading one. In Paul,
yeah,
specifically,
I can't. Yes, this guy was admitted as an expert. Sadly, I checked a bit ahead while we were watching it. He was accepted. Okay, folks, we have gone through quite a lot today. We are 3 hours in. Let me see who I can redirect you to. I can see that Mo, Kurt, and Lincoln Kane. Mo needs it more. So I will redirect you to Mo in the deep end. And thank you all for showing up. Become a member, like, subscribe, every YouTube thing. Tomorrow I might do a thing on Andrew Tate, but I'm not certain yet. But whoever you are, whatever you're doing, have fun doing it. I'm having a blast doing this. Thank you all for showing up. Have a nice day, and I'll talk to you later.